But we're saying to you the facts that we put before you were not before the court below. Bearing in mind now that no further postponement is going to assist, things have moved on, and in fact also there's new evidence that we have now. You would say, but you're coming to us as a court of first instance, because you are not coming to us.
Excuse me, I'm trying to understand this matter because it bothers me a lot. Are you saying that the route of coming through direct access was in order to ameliorate the case that was in the electoral court?
It was to seek relief we couldn't seek before that court.
And you are saying that we don't have to be concerned that a party who then realizes and wakes up one day and realizes that they did not seek certain relief in the High Court will then come to us through direct access, not through a direct appeal, and will also not seek to supplement their case in the High Court. You say we should not be concerned about that?
No, Justice Cheeky, because that would be different. If you sought the wrong relief before the court, you can't get the right relief in this court on the basis that that court could have granted the relief that you seek before this court. But our case is that the electoral court could not, on the facts that were then in existence, have granted the relief we seek from this court. It was not able to do, would not have been able to do so. And so that particular fear is, I believe, unfounded.
Okay, thank you. On a different point, the Commission has raised a technical, has made a technical submission on the remedy. The Commission says that they did not make any decision. And therefore, because they did not take a decision, to come to this court and seek to review their decision is not, or is misplaced. I don't know if you saw that in their submission.
Yes, but we're not reviewing that decision in this court. I think that's one of the other parties.
Okay, thank you.
Mr. Loxton, I'm this side, on your left. Let me write on the backs of my brother Madlanga as well as my sister Chikri and say, there is only one simple issue, whether you satisfy the requirements of direct access or not. And if you don't, you stand and fall. Am I correct? Well, before the electoral court, there were the same parties. I'm going to regurgitate what you've argued. There were the same parties, same cause of action, the cause of action being in the functionality or otherwise of the OCNS system. At the heart of your direct access application is still the same substratum that you're complaining about. The pillars of your argument rests on three pillars. It's your direct access and your electoral court, why you did not go to electoral court, for the reason that you've advanced, or to advance before my sister Chicken, and the dispute of fact. Would it be fair if I say that the defense of issue estoppel as raised by the IEC requires us as a court to exercise a discretion in the event where there is unfairness or prejudice? If we are of the view that no unfairness, no prejudice would be suffered by the Labour Party, then it must fail. Will that be a correct proposition to make?
Justice Matopa, I'd put it slightly differently. The default position is that if you want to preclude a party from approaching another court on a particular matter, you must satisfy the requirements raised judicata, which they haven't. If you want to preclude them on the basis of issue estoppel, you must persuade the court that on the facts of the case, it will not result in unfairness or prejudice to adopt it, and it would be an appropriate approach for the court to take. So the onus is on the Commission to persuade you on those issues.
Excuse me, sorry to interrupt.
Not at all.
Isn't this purely a change of venue? You've just relitigated the same issues, asked for a different relief. Whether it happened at the Electoral Court and happened here, it's a change of venue. Nothing has changed in substance.
Yes, there are a couple of things that have changed. What hasn't changed is that the issue of the functioning of the system hasn't changed. What has changed is you now have new facts in front of you, which the Electoral Court didn't have, which is how many people, the percentage of people who failed to upload, which is a very important fact which they didn't have. The relief sought is different and couldn't have been sought from the Electoral Court.
If I interrupt you, I'm sorry if I'm doing that to you. You know what is my worry is? If the Labour Party suddenly has stumbled upon, so it says, upon facts which motivates it to approach this court on the basis that there are new facts that warrants the intervention of this court directly, but when you look, strip off all its bare essentials, what is the crux of this case is the system did or did not work. Whatever case, how you dress up your case or clothe it, it takes you home to one point. That system on a particular day did not work. And that's an issue that has been addressed by the Labour Court, by the Electoral Court. And like my brother Madlanga put it to you, it's a question of fact. And that being the finding of fact, the test is clear. Under what circumstances can this court, as an appellate court, interfere with the findings of fact? But this is for the other parties, probably not for you. Now, they'll have to surmount that issue. You are saying yours is different. I don't see it. Explain it to me.
Justice Matopo, I'll see if I can do it, because we're now dealing with issue estoppel. And we can accept that res judicata will not work. So the Commission relies on issue estoppel. And there are two factors which, in my submission, would militate against upholding issue estoppel and precluding a hearing. The first is that the relief now sought couldn't have been sought before the Electoral Court, and therefore you would be precluding a party from getting the relief which it says is the only viable relief that that's available, and you would be condemning it to say you should be satisfied with an outcome which was based on different facts where you couldn't seek this relief and a dispute about a 4-day extension. So that's the first thing. The second thing, and I've said this before, so I'm going to bore you with repetition, Justice Matopo, a very salient fact was not placed before the Electoral Court by the Commission, and that is the very significant failure rate of parties to upload. So if we had, for example, gone on appeal, we would have been in this position. We'd say, but are we now stuck with the findings made by that court on evidence which did not include very important evidence which the Commission didn't provide? And we would say, well, that would give rise to unfairness. So upholding issue estoppel would mean that we would be left with a decision of a court made on imperfect facts, and facts, moreover, not disclosed by the Commission, which seeks to maintain that decision. Who knows what that court might have done if they'd been faced with these facts?
For a judgment in your favor, one has to interrogate the facts. Is that correct?
Certainly, Justice.
And if we are to rehash the facts, there is a finding already on the facts. Now, I just want us on a jurisprudential level, which test do we apply as the apex court when we have to evaluate the facts? Do we take into account what the Electoral Court did, or we approach this case afresh?
If it's an appeal, you would look to see what they find. If it's direct access, you would look at the facts before you now.
So if we look at the facts before us now, we would have to forget what happened at another forum and say we have a newborn baby here, we must deal with this newborn baby.
I wouldn't put it so strongly, Justice.
Well, it is that way.
But you would not be bound by the decisions of that court.
Is this not where the shoe pinches? Because if we are unable to peep through those facts, we have a problem. We cannot approach this case on the basis that it is entirely new, unconnected with anything. We know for a fact that the gravamen of your case is that the system did not work. And for us to make that find that the system did not work, we have to look at the facts. Absent any regard to the facts, we can't come to any decision.
But what we're placing in front of you is the system didn't work, and we can demonstrate it was not fit for purpose. And we can demonstrate that by showing you how a significant number of people who were unable to use it properly, not before the Electoral Court. So it would be a denial of justice to say to us, this court must decide a matter on the basis of facts which excluded a very material fact.
I just want to see it and take me through a judgment writing process where I've heard the argument. I have to sit down and now write the judgment. So I have to write this judgment based on what this application for direct access is concerned, and shut my eyes to the problems that you may have faced and the responses that the IEC may have put up in support of its case. So it will be a judgment as narrowly as possible. Is that how it's supposed to be?
It would be a judgment on the facts before you now, not on the facts before the Electoral Court, and you would not be bound by the decision of the Electoral Court. If we were on appeal, it would be different, but we're not.
Okay, thank you.
Mr. Roxton, there are still more questions for you, and I propose that we take the adjournment, just to give you a breather as well.
As your lordship
We'll
pleases.
come back at 15 minutes. Okay, 5 to 12. We'll come back at 5 to 12. Yeah.
not permit the delivery of supporter signatures in physical form. They're only permitted to be uploaded. The Commission said it decided to act outside of its legal mandate by allowing people to submit signatures by hand. They rely on an email which is an attachment to the answering affidavit. We do not read the email, at least as saying that clearly, and certainly the Labour Party did not understand that it was permitted to do so. It was looking at the legal structure. So the first part was we didn't understand from that email that we were entitled to do that. Second thing is that it is anomalous that the Commission should cite to this court cases which say it is strictly bound to comply with the timetable and the rest, and then say, but we allowed a deviation. I understand, and you will recall that the Commission has also said that they're not entitled to make ad hoc changes. That was an ad hoc change. There's another recent ad hoc change which I understand has happened, which is the extension of the deadline from 5 o'clock to midnight for the delivery of certain information. So, simple point is we didn't understand that we were entitled to do that.
Thank you. I'm also grappling with this 35%, 65% question, and I'm trying to understand the relevance in terms of law. As I understand it, your argument is that your rights essentially to stand for office have been violated in Section 19, that the applicable legal framework is New National Party, which in paragraph 21, Justice Yaqub for the majority said Parliament must ensure that people who are otherwise eligible to vote are able to do so if they want to vote and if they take reasonable steps in pursuit of the right to vote. And we read that to by relevant changes to include the Commission must essentially provide individuals with a reasonable opportunity to be able to realize the requirements for candidature. We have a situation where 65% of people were able to, or unrepresented parties were able to register properly and conform with the requirements, and 35% were unable to. If there were only one party, for instance, that was unable to conform, we are dealing with rights. Usually we would consider it from an individual point of view, but what would the significance of that be for the reasonableness of the system itself?
Yes, there are two ways of testing the system. The one way is to test it by asking, does it function in the manner in which it was designed to function? And there you have the evidence of the Labour Party that there were flaws in it as they experienced that certain things happened. The other way of testing the system is it fit for purpose? In other words, was it a system in which the overwhelming majority of parties were able to comply? So was it designed in such a way that it enabled parties generally to upload the information that they wanted? And we say that if it were one party, so if one party gets excluded, you're looking at that to say, well, obviously that is your Section 19 problem. But if you're looking to see what was the system, was it a reasonable system, which is a word that the Commission uses, then it's not a reasonable system if a significant number are unable to use it for whatever reason. Then you must redesign it. It's like the Banking Act.
Does it not depend on the reasons that people are unable to use it? So, for example, if the system worked perfectly, but various people around the country, different parties were unable to access it because of poor internet connections, would that not affect our assessment of why, whether or not the system was fit for purpose.
It could, except that you're looking at it from an overall point of view. So, the families that are unhappy in different ways, and families that are happy in the same way. But every person might have had a slightly different reason. But the fact is they weren't able to do it. And that's why when I look at the 35, I'd say, but if we'd reversed it, if we'd said 65% couldn't use it, you probably wouldn't hear an argument that it was each one's fault. There would have to be a concession that actually the system is not fit for purpose. So as you go down the scale, you will hit a point where you say the number of people who couldn't upload the information is not sufficiently significant to demonstrate that it was not fit for purpose.
Okay, thank you. My last question is just around remedy. The remedy you request is a drastic one, and as we've heard from the respondents, involves significant cost and repetition of processes. And so I'm just wondering if in your submission there's any alternative remedy that could satisfy you. My understanding, for example, I recall there were parties that came into the election process in the first election in South Africa very late, and they were sticking on the parties onto the ballot papers. I'm not entirely convinced why, from the respondent's side, why expedited processes in that regard would not be possible. But you seem to suggest that it's not possible, and therefore we must go for the most drastic alternative.
So yes, if we knew of a way to avoid the postponement, a way to allow participation through a process of truncated timelines and maybe a recognition of a post facto recognition of efforts made, we would do that. We relied on the IEC's opinion, the Commission's opinion, that it was not possible. But if the Commission were to come to the court to say, we have actually devised a system which allows the election to take place on the proposed dates, we would welcome that, because the point is not the postponement, the point is participation.
Thank you.
All right, there are no further questions for you as it turns out, Mr. Loxton. Thank you.
Thank you very much. I think I preferred the earlier arrangement of 10 minutes free time. Question.
Yeah. Mr. M?
Thank you very much. In the time that I've got, I'm going to address 9 issues. We obviously stand by what we say in the heads of argument and the cases we referred to. I'm going to give an introduction, and I'd like to apologize in advance if it's somewhat sentimental, but it's really what I just want to put to this court is this court's own judgments about the importance and the value of the vote. Then I'm going to deal with the application for direct access, leave to appeal, the question of urgency. But in dealing with that, I'll also deal with this court's jurisdiction within the context of an appeal which has disputes of fact at its heart. I'll also deal under the second point with the point taken by my learned friends for the Commission that the approach we've adopted is not proper in terms of Section 96(1) of the Electoral Act. Then I'll deal briefly with the application for leave to leave new evidence on appeal. I have somewhat nervously listened to the question put by Justice Majid to my learned friend, but I hope to answer that question because we do oppose the application for leave to leave new evidence. in this appeal. Then we'll deal with what we believe is a fundamental aspect of this case, and that's a misconstruing of, in actual fact, what my client's case is. And the misconstruing is fundamental, and I'll just tell you what it is very briefly. My client does not have any complaint about the election timetable. It's got no complaint about item 9. Its complaint centers on its ability to comply with item 9 in circumstances which are beyond its control. But the electoral court proceeded on the basis that my client's complaint related to the timetable and item 9. We then deal with certain of the fundamental decisions, because that's a good way to segue into the electoral court's decision. Then we'll deal with the factual disputes. We submit that there are no, with respect, genuine, serious factual disputes. And you don't need to go through the affidavits with a microscope to find that there are no genuine factual disputes. In actual fact, on the respondent's own version, Commission's own version, there were complaints. On the Commission's own version, the system is not perfect. Now, we're not advocating for a perfect system, but we'll deal with that in due course. Then I would just like to take the opportunity to deal with certain of the submissions made in my learned friends' heads for the Commission, which we believe decontextualize or potentially misconstrue. And I certainly don't submit that there's any animus in that or that it intentionally happened, but we just take a different view on certain of the submissions contained in the Commissioner's heads of argument. And then is the difficult question with respect to the horns of on the horns of a dilemma which this court faces, if obviously you find for us, is what now? What must happen? And in that context, I would want to deal specifically, and I intend to deal specifically with the Declaration of Rights that's proposed by the Commission. Now, Section 19 lists the political rights in issue. But Section 19 is certainly not exhaustive of what those political rights entail, because Section 19 doesn't include, but it's regarded as forming part of the political rights, and that is the right to stand for election for political office within the context of being nominated by a political party to do so. So the Section 19 right that we ultimately will submit and hopefully persuade you that lies at the heart of the factual dispute is whether or not the right of my clients, and at the very least 121,000 supporters, that's the supporters list that my client uploaded, that at the very least 121,000 people will be denied an opportunity to vote for the party that they want to, and a party that they've already put their hand on their heart and said they're going to support because they're in the supporters list. And then the exclusion of 470 candidates of my clients who want to stand for my client on the ballot list, their exclusion. So it's two sides of the political right. It's the one to vote for who you want to, and the other one to stand for office. And ultimately whether the frustration of either of those rights, which we submit is presently the status quo, has the effect of rendering the elections unfree and unfair. Now, this application traverses what I recall some years ago, Professor Corder, Professor Murray at UCT telling us, right when this was all new, I'm showing my age, what they called red rights. You had red rights, you had blue rights, you had green rights. The most fundamental and the most important are the red rights. Now, the red right here is the right to vote. It's the right to a political franchise. And His Lordship Justice Sachs, in August versus the Electoral Commission, 25 years ago, said the following, and it applies still today. The vote of each and every citizen is a badge of dignity and of personhood. Quite literally, it says that everybody counts. In a country of great disparities of wealth and power, it declares that whoever we are, whether rich or poor, exalted or disgraced, we all belong to the same democratic South African nation. Our destinies are intertwined in a single interactive polity. Rights may not be limited without justification, and legislation dealing with the franchise must be interpreted in favor of enfranchisement rather than disenfranchisement. So in that regard, and if I can just quickly jump ahead to the relief the question as to what relief would be granted. We would submit that an appropriate relief that favors enfranchisement rather than disenfranchisement is the appropriate way to go. This court in New National Party, also in 1999, held the following. The Constitution takes an important step in the recognition of the importance of the right to exercise the vote by providing that all South African citizens have the right to free, fair and regular elections. It is to be noted that all South African citizens, irrespective of their age, have a right to these elections. The right to vote is of course indispensable to and empty without the right to free and fair elections. The latter gives content and meaning to the former. The right to free and fair elections underlines the importance of the exercise of the right to vote, and the requirement that every election should be fair has implications for the way in which the right to vote can be given more substantive content and legitimately exercised. Now, we submit that the fairness, as I've already indicated, includes the right to stand to before election in the upcoming elections. There's unfortunately an unnecessary pejorative tone to the Commission's opposition to this application. And its opposition and the way it's adopted its attitude in opposing this application is somewhat disappointing. And the reason why I say that is the Commission is required to be neutral and independent. It's required with respect. It's a professional litigant. It's a statutory litigant. It's a constitutional litigant. It litigates. And you would expect from somebody who's neutral, importantly a Chapter 9 institution, to place all of the relevant facts before the fact finder when there is a dispute about whether an election is free or fair. And what we have here is a disappointing failure by the Commission to do that. In actual fact, the Commission has done the exact opposite. It's kept its cards very, very close to its chest. And we submit that's dispositive of the dispute of fact. Because when you look at the disputes of fact, it's more about what the Commission doesn't say than what it does say. But I'll deal with that in due course. The other pejorative tone, and I say this in the following sense, the word failure ordinarily has a pejorative negative inference. And the term that's repeatedly used in respect of the affidavits and the heads of argument is that my client failed to comply with item 9 and section 27. It's not a question of failure in the pejorative sense. It's rather a question of an objective inability to comply. So it's not a subjective or negative framed failure, but an objective inability. Now, and that object inability is, we submit, is that the portal malfunctioned. But it's not that the portal crashed. We don't suggest the portal crashed. We don't claim the portal crashed. We don't claim that the portal wasn't live. But what we do claim, and it's supported by various other parties, even the Commission itself, that on an ad hoc and random basis, the portal lagged, it stalled, it hung, it required users to log out and log in again. And in logging out and logging in again, the information that had been captured was lost. And that, with respect, deals with the factual dispute, which I'm going to come to. Because there is supposedly reports, I say supposedly, there are reports by IT, I think Lockdown, and all they tell you is that the portal was live. It was up 100% of the time and it didn't crash. But that's not the complaint. So it's about trying to upload something. And a classic example would be when you try to upload a document that's too big or email a document that's too big. You know that that email is going to sit in your Outlook, in Outbox until it's sent. So it's the same here. It doesn't mean that the system was imperfect. The question is, was the system fit for purpose when it should have been? And that is on the 8th of March, particularly in the afternoon, where you have the evidence from the Commission that thousands of other people were uploading documents. And we'll get to, in due course, the question about, well, if thousands of other people or submissions could be uploaded, why couldn't your client do it? Surely that indicates that the system works. We, with respect, disagree. But when I say to you, I don't want to be sentimental, but what price can you really put, with respect, on the right to vote? Something that mothers lost children for, wives lost their husbands, sisters, people died for this right. The Commission says a postponement is going to cost R500 million. We don't agree. We say on your papers it's going to cost 284 million. Still a significant number. But let's break it down to the actual identified votes. We know that there are 121,000 supporters of my client. Taking that just short of the 300 billion rand to a cost per vote, it's 2,504 rand. If you add the 55,000 supporters for Mr. Loxton's client, the Labour Party, that cost goes down to 1,721 rand and 59 cents. What price do we put on the right to vote? And at a minimum, what does it cost to ensure that South Africans are enfranchised and that they wear their badge of dignity and personhood and that they are not told quite literally, you don't count? And that's to paraphrase Justice Sachs. Now, within the context of the application for leave to appeal, as we understand it, that application is opposed effectively on two grounds. The first is that this is an issue of fact, and the Constitutional Court doesn't hear fact-based appeals. We disagree. The Constitutional Court, this Court with respect, has already said that's not the absolute rule. And secondly, a reliance on Section 96 of the Electoral Act. This Court, with respect, is statutorily empowered. In actual fact, it's more than empowered. It's obliged. It is the upper court in respect of all constitutional matters. And there is no doubt that what we have here is the infringement of a constitutional right. Or a claimed infringement, you will decide in due course the merits of the case. But that right, with respect, cuts through so many different layers and so many different provisions of our Constitution. If I can just list them for you. They cut through basically the right, the founding principles of our Constitution, Section 1D, universal adult suffrage and multi-party system of democratic government. It cuts through the founding principles, Section 3.2. All citizens are equally entitled to the right, privileges and benefits of citizens. One of the few rights granted in the Constitution to citizens is a right to vote. Section 19, the political rights, which I've already dealt with. In the August judgment of this Constitutional Court, this court held that the following rights are indubitably impacted upon by the right to vote. Equality, Section 9. Human dignity, Section 10. Privacy, Section 14. Freedom of conscious thought, belief and opinion, Section 15. Freedom of expression, Section 16. Freedom of association, Section 18. It also cuts through the statutory powers of the Commission. And the statutory powers of the Commission have their origin in the Constitution in Section 181, which deals with the institution of state institutions, which are there to support our constitutional democracy, one of them being the Commission. Section 119, which places a positive constitutional obligation on the Commission to manage the election and to ensure that they're free and fair. Section 5 of the Electoral Commissions Act, the obligation of the Commission is to manage the elections and to ensure that those elections are free and fair. And Section 20, and this is really where the right, the doorway into the infringement of my client's right comes. Within the context of the factual issue we're going to ask you to determine. And that is whether or not the Commission invoked its powers, even considered that it was entitled to invoke its powers under Section 22A, which was to amend the timetable. It had the power to do so. It didn't even consider. I stand corrected, and I'll be embarrassed if I'm corrected, but you can trawl through the affidavits of the Commission. You won't find, or the heads, you won't find a single reference to the Commission actually ever considering Section 20. Not a reference at all. What you will say is, well, we weren't obliged to consider it. Well, that's another question. But did you consider it? Did you consider it and then come to a conclusion that it's not appropriate in this instance? Or that the exercising or the amending of the timetable wouldn't result or wouldn't remedy what's claimed to be unfree and unfair elections? Now, within the context of the... Sorry, one last point, I just missed it. This matter indubitably engages this court's jurisdiction in terms of Section 167(3)(b)(1). Now, on the application for leave to appeal, and if I can take the lead from the debate that your justices had with my learned friend, Mr. Loxton, this is an appeal. It's an appeal on the record that's served before the Electoral Court. Now there's an application for leave to appeal, for leave to introduce two vitally important pieces of evidence that never served before the Electoral Court. The first is the lockdown reports, the IT lockdown reports, the expert evidence about the system's failure. The point was taken before the Electoral Court by my clients in a replying affidavit in the heads of arguments, and we argued. No regard can be had to those reports because, first of all, they are irrelevant. And the reason why they're irrelevant is because they only deal with the system crashing and not being live. That's not my client's complaint, that was already pointed out. So it deals with irrelevant matter. The second is that it was inadmissible because none of those reports were confirmed by any of the authors. So the second aspect, which is dealt with now for the first time, is what it's going to cost the elections, to postpone the elections. If I can just quickly point out, there's an amount of R500 million that's claimed, but included in that amount is an amount of approximately R200 million, which pertains to voter registration, the costs of having to go through voter registration again. But voter registration, with respect, has got nothing to do with this case. This case deals with Section 27, the submission of candidate lists and supported lists and the payment of the necessary deposit. So of that R500 million, you can take R200 million off. But that information was also not before the Electoral Court. And the explanation for that information not being before the Electoral Court, there's no explanation. There's no explanation in the application to lead new evidence. As I read the application for leave to lead new evidence, it only pertains to the IT reports. But the explanation given for the IT reports is, well, we didn't have time in the urgent circumstances of the Electoral Court proceedings to put up that evidence. The difficulty with that is they never made application before the Electoral Court for the admission of that evidence in terms of the Law of Evidence Amendment Act. To say, listen, this is an urgent application. This is what we've got. We will endeavour to get a confirmatory affidavit. It may not be filed before this, before the hearing, but we will provide it. Absolute silence. And what is ultimately produced is not simply a confirmatory affidavit. It's a substantive affidavit that deals with the system. But again, it's irrelevant because the expert reports at bundle page 209, what it deals is with the testing as we read it, deals with downloading information from the server. But that's not what it's about. This is about the uploading of information and the speed at which information could be uploaded. So we submitted that report. It's inadmissible, and the new evidence is inadmissible, and it's irrelevant. Now, The electoral court, with respect, we submit misconstrued my client's case. And the reason why they did that is because, as I've already indicated, they adopted the position that my client's case was about the timetable, and that if we had concerns about the timetable, we should have complained about the timetable. That is not my client's case. My client's case, with respect, I won't say articulately, but it's certainly set out in our heads of argument. And if we can put it in a nutshell, is the following. Act's case, broadly stated, in essence, is not one pertaining to the reasonableness of item 9 per se. This is at page 25, the second bullet point of our heads of argument. Or of lateness. Act's case instead pertains to an objective impossibility that precluded Act from complying with an aspect of section 27 within the time frame afforded in terms of item 9. More specifically, Act's case is that the decisions of the Commission are irrational and reviewable within the context of item 9 and the statutory powers it has under section 22. It's also irrational within the context that it was the Commission's platform that malfunctioned. And it's also irrational in the context of the very statutory function, the constitutional reason for the existence of the Commission is to ensure free and fair elections. Now, on the factual position, this court has, in Rail Communications, let me find the reference, we deal with the Rail Commuters Action Group at page 31, paragraph 79, deals with when this court, with respect, is enjoined. It's not a discretion, and I say that with tremendous respect. When this court is enjoined to consider disputes of fact. Rail Commuters dealt with the Bussack judgment, and it says that the Bussack judgment must never be read, that this court may never resolve factual disputes. The reasoning in Bussack does not imply that disputes of fact may not be resolved by this court. It states merely that where the only issue in a criminal appeal is dissatisfaction with the factual findings made by the SCA and no other constitutional challenge is raised, no constitutional right is engaged in such a challenge. Where, however, a separate constitutional issue is raised in respect of which there are disputes of fact, those disputes of fact will constitute issues connected with decisions on constitutional matters, as contemplated in terms of section 167(3)(b) of the Constitution. And we accept that we're not at large to simply ask this court to consider the facts. We accept that. We accept the court's position. We do it absolutely without demur. But what we suggest is that what we submit is that this dispute of fact strikes at the very heart of the constitutional issue. It strikes at various provisions within the Constitution. In Rail Commuters Action Group, page 31, paragraph 80 of our heads, the rule was held not to be immutable. There are exceptions to this rule, and the court held where an applicant seeks constitutional relief and there's a dispute of fact on the papers before the court, the identification of the issues upon which the constitutional matter should be adjudicated constitutes an issue connected with a decision on a constitutional matter, which falls within this court's jurisdiction. In such circumstances, this court is not bound by the facts as determined by the SCA. So, if I can just deal with the factual dispute, such as it is, we submit that there are various objective common cause facts about which there can be no dispute or no serious dispute whatsoever, and those disputes, such as they are certainly not bona fide within the following context. The following objective facts are: my client started on the 21st of February with the uploading of the supporters list. 4 people used the single person's logon user code. They were supported, though, a team of 4 was supported by 20 people who were skilled and had access or used new laptops. A venue was secured in the middle of Sandton for this purpose, and that venue had internet which operated at high speed and was stable. All the required information for the processing of the submission was available. My client had successfully uploaded more than 121 or 121,000 supporters' names and signatures. It had paid the deposit. So for the Commission to say that my client didn't understand how the system worked is with respect belied by the facts. It struggled. I'm not denying that. And there were these difficulties, but it still managed to put up its supporters list. It had to pay the deposit. That my client experienced difficulties and delays is also not in dispute. The fact that it phoned the IT call center to raise these complaints is not in dispute. The fact that the best IT call center could do to tell my client was to log on and log off again is not in dispute. And the fact that logging on and logging off meant that you lost all of your information, which had been uploaded, is not in dispute. It's also not in dispute that all my client required, and this is on the Commission's version, to upload its candidate list was an hour or two. It's not in dispute that my client had an hour or two. It started at 14:53 on the 8th with the uploading of the candidate list. So it's not in dispute that there were various political parties that raised the exact same complaints as my client did about the platform glitching and hanging and about it stalling. And none of those complaints relate to whether the system was live or not, or whether it crashed. They all relate to the same thing, the glitching, the malfunctioning of these difficulties. And we now have an acceptance from the Commission, well, we deny that the system failed. Despite us acknowledging that other people complained, and we refer to those particular positions, it adopts a contradictory position in the affidavits filed before the Electoral Commission in the Labour Party Act. We had admitted other parties had complained. So what we have here is a dispute of fact that, with respect, cannot survive even the most superficial scrutiny, because the dispute is resolved solely on what the Commission acknowledges and what is common cause. And it begs the question, if my client had been able to upload 121,000 supporter lists and names, why was it unable to upload, in only the hour or two it needed, the names of its full candidate list? Now, there's a reference in the papers to two other political parties that managed to do it at the last minute. But there's nowhere, and this is where the Commission isn't candid. We don't know if we're comparing apples with apples. We don't know how many other candidates were required to be uploaded for the other political parties. It may have been one, it may have been two. Not 540 odd, as my client had. And as for the second of the parties, it was the African Independent Congress, the Commission actually helped. So, with respect, we submit that there's nothing that can be done. Lastly, I just want to deal with the declaratory relief. The declaratory relief doesn't remedy the infringement of a right. All it does is pat my client on the back and say, sorry for you, life's not fair. But the elections are supposed to be free and fair. And we submit, as they stand at the moment, they're not free and fair. Thank you.
So what kind of order do you want us to grant if we find in your client's favor?
It's very difficult, Deputy Chief Justice Meyer, because my client's case, and this was a difficulty with respect before the Electoral Court, my client's case got contaminated by the other cases. My client's case is quite simply, you say we need an hour or two, give us an hour or two. That's all we need. We don't need the whole process to be opened. We don't need anybody to go back in time. Just give us the hour or two you say it would take us to upload. That's the relief we would receive. Obviously, the postponement of the election is the most drastic relief. And I don't want to be free with taxpayers' money. But if that is what it costs to give recognition for a right that people gave their lives for, then that's what it costs. So we would obviously ask for a limited relief. Just give us access. If it's impossible to give us access and that results in the postponement, then I'm certainly not flippant. I don't want to say so be it, but if that's what happens, then that's what happens. But the primary result is, Deputy Chief Justice Meyer, is the non-postponement of the elections and the non-granting of my client's right is some relief. does not render what is already an unfree and unfair election free and fair with respect. Because it's already unfair and unfair. We're asking here, we come here to this court, and we're asking for relief to assist us to allow supporters, voices to be heard, and to allow 470 people to be on the ballot list. So it's a very difficult question. That's the horns of the dilemma. But if it needs to be postponed, it must be postponed. There's sufficient time with respect because it's only the 19th of April. 19th of August, I believe, is the last date for the election. You read, and His Lordship, Justice Majid dealt with it, albeit in a throwaway comment where he dealt with the conjecture. We know nothing about what the other parties, other political parties' inconveniences or their cost to them by postponement of the election. We don't know anything. None of them have come and told you. It's with respect not for the Commission to speak on their behalf, but what we do know is that they could have come and told you within the context of the Labour Party's application, because they were cited in that proceeding. But nobody's come forward. So what you have here is absolutely no evidence other than conjecture and speculation that other parties will somehow be inconvenienced or will suffer financially or don't have resources that can survive a postponement. There's with respect no evidence before this court.
Mr. Am, I am still on the relief sought. The IEC said that it cannot just open for one party.
Yes.
If it opens, everyone would have to come in. And that's why then one ends up with a postponement. What do you say to that?
It's a very difficult question that you ask, and one that myself and my juniors have wrestled with. The question is, my client has exhausted its rights to be able to participate. It raised an objection. It went to the electoral court. It lost 3-2 in the electoral court. It comes to this court. It has taken all of the steps it requires to protect its rights. Other parties don't appear to have done that. We don't know the reasons why they haven't done that. But all we know is that my client is, with respect, asking for an hour or two. Whether this court decides that fairness dictates that then it must be opened up to everybody, just the Section 27 process, then that's what fairness dictates. But my client, with respect, can't be non-suited in a sense, and I say non-suited because the court may decide in its wisdom to not reopen because then they have to reopen for everybody. But why should my client be prejudiced because the other parties who are similarly situated never exercised their rights, never came to court and complained? So it's a very difficult question you ask you, and it's really a policy-laden answer. But all I can say is my client has exercised its rights. It shouldn't be prejudiced because other parties haven't, with respect.
Thank you. You criticize the IEC for having told us the cost implication of the postponement of the election.
Yes.
But surely, and you say that that is something that was not before the electoral court.
No.
It was not before the electoral court because that issue was not raised at that level. It's raised before us by one of the parties. And because of that, the IEC has a duty to then tell us what the implications of a postponement. We as a court, we need to know that information.
Yes. Justice Mfantla, I think there are two answers to your question. The IEC was quite clear in its affidavits before the electoral court that if the relief sought is granted, they cannot guarantee free and fair elections on the 29th. So they knew even then, before the electoral court, that there was a risk that a postponement may ultimately eventuate. It was put to my learned friend, I think by, trying to remember, one of the justices in the electoral court. It may have even been Justice Adams. What happens if we give the relief? My learned friend says, well, then what we will have to do is ask the president to postpone. So it's always been an issue. But there's no explanation as to why that evidence, with respect, despite it being there, wasn't put before the electoral court. But our complaint, sorry, maybe I'm not maybe, I didn't make it clear. Our complaint so much about the new evidence doesn't directly impact on the cost. We obviously accept there's a cost. We obviously accept it's going to be very expensive to postpone the elections. Our real complaint is about making out a case that you never made in the electoral court when you were told you hadn't made a case in the application here. And what's important, sorry, with the report, as they said in the application to lead evidence, that we couldn't get this in the time available. But as we point out in our heads, they asked for the report in the context of this application, and they got it the next day.
Okay, we're moving to the report. Okay,
Yes.
let's put that
No, no,
on.
but
Just
hopefully
for
ask your question.
clarity, for my understanding,
Yes.
you, in your papers, you refer to direct access,
Yes.
and at some stage you say
That's-
direct appeal. Tell us exactly what I'm seeking.
What
And
we-
you
what-
also refer, you then deal with the judgment of the electoral court. I would believe that would be an application for direct appeal, not direct access.
Well, what-
But I don't want to make the assumption
No.
if you are
What
maybe applying in the alternative or what.
We put it inarticulately, and I apologize. We did it under tremendous pressure. You will see, I think, the application to this court, I think, went out a day or two after the electoral court's decision was handed up. What we're asking this court, what we're telling this court, is the electoral court got it wrong.
So that's direct appeal, no
We don't-
direct access.
Yes, we don't have time to go to the Constitutional Court. Please, can you help us? In these urgent circumstances, we've got an election on the 29th.
No, that's fine then.
So,
Then,
sorry,
Yes.
it was inarticulately, but that's what we want. We want some assistance from the court.
thank you, thank you. You said that you were registered, your party was, okay, the applicant, no, I did not say your party, the applicant was registered on the 21st of February.
That's when it first obtained access to the system, the 21st of February.
You see, there seems to be some confusion about the timing of the payment. It seems as if it waited until it made the payment of the deposit before uploading the candidates. And my understanding from the IEC's perspective is that all that is required is for the party to get the reference, payment reference, then do the upload, then pay. So why was that not done in the case of the applicant?
That's a very good question. My client says, if I can just go back, and it's not disputed, that the parties were strongly advised to use the system, not to make hand deliveries. And we already know that the submission of the supporter lists had to happen through the system. My client understood the position, and its understanding is not challenged. The correctness of the understanding is. My client's understanding was, well, before we can go to uploading the candidates, we need the system to tell us what is owed and what deposit must be paid. And in actual fact, if you have a look at one of the flow charts, and we refer to it in our heads, one of the flow charts from the manual from the website shows you that you pay the deposit before you move on to the candidate submission process. So if the commission understands it one way, its documents say it another way, and we understand it the way we did, then it begs whether the system was an appropriate system. So that's the answer. That's what we understood, that's what their document says. Albeit I don't for a moment suggest, because it's not in the papers, that when we did that, we looked at the document. I'm certainly don't want to, I'm not being opportunistic, but the document confirms what we understood the position to be.
Now, having realized that you had problems, you said this started around 14:53 or 3 o'clock,
Around-
and you were not far from the offices of the IEC, about 40 kilometers away. Why not make a physical submission of the...
If I can answer that on 3 levels. The first is, as I've already indicated, and it's not in dispute, the parties were strongly advised to use the system. That's the first level. The second level is that the system, when it worked, it was quick. That's not dispute. We say that in the affidavit. When it wasn't glitching, it was quick. So the third level is now my client sits on this horns of a dilemma. It knows at any time the system can be fully functional and everything can go through, or does it stop doing what it's doing, pack everything up, get in a car and drive to Centurion. Ultimately, that's what it did. It packed everything up and drove through to Centurion. It did it a bit late. I think they say they left in the affidavits at 4:20, and they got there after 5. But that's what they did. But it's the horns of a dilemma. Do you do this or do you do that? Knowing that you might get stuck in traffic on the way there, or is the system going to suddenly function perfectly or smoothly? Let me say smoothly. It's that horns of a dilemma. I certainly don't think the criticism that my client could have submitted it physically is something that can really non-suit my client, because it did what it could.
Thank you, Mr.
Thank you.
Mr. M,
Justice Majid.
I want to understand why you say there's no dispute of fact here. I thought the central issue was what did OCLS work or not, and if it didn't work, it wasn't fit for purpose, was that the cause for this non-compliance? Isn't that a central issue?
No, that's a central issue. But the question is, a dispute is raised about that issue. The answer, how you answer that question is twofold, and they indicate processes. Is it a serious and genuine dispute? And in determining whether it's a serious or genuine dispute, you analyze the dispute and you see what the parties say regarding the dispute. Now, there's a dispute in inverted commas, but it's not genuine. And the reason why it's not genuine is because there's objective common cause evidence about the difficulties my client and other parties experience. That's objective, it's not disputed. So we know that there were complaints by various parties about the functionality. We know that. What we do know is what we don't know, sounding like Donald Rumsfeld. He said, we know what we know what we don't know, and we don't know what we don't know. But what we don't know is what parties complained, like my client complained about glitches, to the hotline. And which of those parties are now part of the 35% who've been disenfranchised because of the system? We don't know. The only custodian of that information is the Commission.
Let me just stop you there and make a quick correction, which is very, very important for the narrative in this case. It's not 35% of the electorate.
No, absolutely.
35% of unrepresented parties.
I beg your pardon?
35% of unrepresented.
Yes. Sorry. I'm talking about if you want to try and put the same apples in the same basket. We don't know what the position of those people who complained. We don't even know who they are. We're not even told. And we're not even told what the outcome of the complaint was in the context of whether they were precluded or not. So we don't know what we don't know, and the only person who could have told us is the Commission.
All right, let's just switch off your microphone like this. Let's interrogate this answer. How many sub-users did the ACT have?
We had 1 registered sub-users and 4 people using that license, or using that access.
Okay, the short answer is 1. Did it upload manually or in bulk?
It uploaded manually. It was for the supporters list.
When did it pay its deposit and upload its signature, supporter signature list?
It struggled to pay its deposit on the morning. It ultimately paid the deposit sometime in the early afternoon, and it started at 14:53 with the uploading of its supporters list.
Short answer is on the 8th of March. Now, so on the 8th of March, the system works well enough for you to do all of those things, pay the deposit and upload all those thousands of supporter signatures. So how come what's good for the goose isn't good for the gander? How come suddenly now we're in a different ballpark with the candidate list on the same day, same party?
No, with respect, Justice Majid, my client commenced the supporter list process on the 21st. It had a team of 20 people there. It hired a venue. 4 of the people used the access code. There was 1 access code, 4 people used it. It completed the supporter submission list on the 6th of March, except for I think one of the provinces. It then completed that outstanding province. It then attempted to pay the deposit because it believed the deposit had to be paid before you go on to the next step. So with respect, whilst the complaint is ultimately rested on the inability of the system to function, my client does say in the affidavit that its ability to upload the supporter lists and the deposit list was extremely frustrating for the same reasons. So it's not that with respect my client left this till the last minute on the 8th.
Now, when one looks at fairness and you talk about objective impossibility, those are self-evidently objective assessments. Now, what about all the vast majority of represented parties who are able to do all these things by the 8th of March? What about the 65% of unrepresented parties who are able to do so? If you talk about objectiveness, surely we can't be bound by subjective experience of your client and others.
If I can just deal with the last point first, just to clarify, and we disagree with great respect, classifying my client's experience as a subjective experience. It's an objective experience. As an objective fact, the system glitched, it hung, it stalled, it kicked users out, it reverted to the home page. That's an objective fact because there is no evidence from the Commission, admissible or otherwise, that suggests otherwise. We also have as an objective fact the complaints that were made. So I say this with great respect, we don't agree with the classification of my client's difficulties as being subjective. They were objective. Now to go to the position of the 65% that managed to do it, if I can answer that question by looking at the other side of the coin, my client had successfully done everything it needed to do. The Commission says that it needed an hour or two to deal with the last process. It had an hour or two. So to say my clients didn't know how the system works is belied by the facts because it got to that part. It's like driving to Cape Town. It got all the way to Worcester and then suddenly the car doesn't work. That doesn't mean my client now doesn't know how to drive, doesn't know how to use a car. My client knew how the system worked. It was frustrated in the use of the system. And when it really push came to shove, and we have all these thousands of people attempting to access and download and submit candidate lists and supporter lists in the afternoon, the system simply wasn't fit for purpose. But so if I can just answer one thing, in the context of you asking, did my client submit the supporter list manually? It did. But what you do have, with respect, is the evidence, the video footage of the land party, which shows the system failing. And the Commission's answer to that is yes, but they were manually uploading. But if if the information you're uploading manually is a lot more limited and less burdensome than a bulk upload, if the system wasn't even tolerating manual uploads, what would it have done with bulk uploads? Because we know in the affidavits we're told that bulk uploads you needed to split files and download them separately. So I forgot to deal with your point and your question around the manual uploads.
See, on the conspectus of all the evidence, this is what we have. We have a party that waits until the last day to do what is absolutely essential, and it's a new party, it's keen to participate in these important elections. And I've said this before to Mr. Loxton, so you will hear it again because you're a different party. Let me hear what your answer is. So they wait till the last day. They don't engage multiple users like others, for example, the Patriotic Alliance, also a new party did. They don't do bulk uploads like many others have done, and which is the most efficient way of doing it. They use manual uploads. And then you ask the court to come to your assistance where the overwhelming majority of other parties were able to do so. Do you think that's fair?
I think with respect to say just because other people did it and my client didn't.
Sorry, can I just interrupt you? There are two judgments of this court. And remember, we are bound by it's Liberal Party and Inkatha Freedom Party. Both those cases say this. It says for elections to be credible and for the Commission to have integrity, we must have two things. We must have rigid adherence to the rules. Everybody knows what the rules are. So if you allow anybody to stray from the rules and say, listen, come, just help me out, it can't work like that. So there has to be a rigorous adherence, but also there has to be even-handedness. For elections must not only be free and fair, they must be seen to be free and fair. It's much like justice. And so how do you justify accommodating these parties when the overwhelming majority has done what they had to do, and the election timetable was never under any challenge? You didn't challenge item 9, you didn't challenge the regulations under which it was passed. So on what basis is it fair to do this for you and not for others?
The premise of the question with respect is that the majority rules. The question of fairness.
It's what Liberal Party and Inkatha Party says, even-handedness and rigid adherence.
Yes. Well, both of those judgments are, with respect, distinguishable on the facts. They both deal with parties that were just late, who endeavoured to do what they were required to do after the fact. That's not the case here. Secondly, the fact that 66 or 65% of the people did it means that there are 35% of the people who were unable to do it. And it certainly can't be, with respect, fair to adopt it just, well, the majority did it, that's fine. Because that's with respect not fair, because my client's inability to do it was because of reasons, an objective impossibility. Not because of they left it for the last minute. With respect, we also take issue with that. They started on the 21st. They set in place, they took various steps, they incurred money, they hired venues to do what they needed to do from the 21st. So they never left it with respect to the last minute. But if I can just deal with the last minute argument, in our heads we refer to the new National Party, the National People's Party case. Because that case deals squarely with somebody who left it to the last minute and a claim of tardiness. My client wasn't tardy with respect, it just wasn't tardy. It had the time to do what it needed to do if the system worked. But in the National People's Party case, the contention, namely that the applicant's woes were self-inflicted by reason of it not acting in good time, is imprudent and simply lacks respect for the applicant's rights. It's not capable of being sustained. The fact of the matter is that the timetable had been established and requirements can be fulfilled at any time within the confinements of that timetable. That a particular party or person chose to comply therewith at the last minute does not detract from the right to participate in the election or exercising the right to do so. So to suggest that the applicant only has himself to blame and that the chairman would not have had to rush if the requirements had been complied with long before is not helpful. The applicant was entitled to submit the documents at any time before 5 o'clock on the 25th of March 2011. My client needed an hour or two on the Commission's version. It had an hour or two. It couldn't do it.
Now, and what that case, which in any event doesn't bind us, what that case doesn't deal with is the question of the methods that you use. You use the most inefficient methods at the last minute. That is what is the distinguishing factor.
Mike, if I can just answer that about the most inefficient method. My client says its understanding was that it had to pay the deposit first and that the candidate submission list had to be done manually. That's its understanding.
Yes, thank you.
Mr. Am,
Yes.
earlier in your submissions, when you were taking us through what your case is all about, you said that you are not attacking the timetable. Yet, you are saying that we must give you an extension of 2 hours or so. Are you then not asking us to extend the timetable when you ask for that remedy?
Well, the basis upon which we come to court, Justice Cheek, is the following. Due to an objective impossibility, we never met the item 9 deadline. The Commission had it expressly within its power to exercise a right given to it under Section 20 to amend the election timetable. We know from the affidavits that it had previously, at the outset, amended the timetable. That's our complaint, is that the Commission did not did not even consider the right it had to extend. So it's within that context, the Electoral Court could have granted any order. It was at large to grant any order that would remedy that. It's not constrained, and this court, we submit, is also at large to grant any order that ensures a free and fair election.
Was the timetable reasonable?
The timetable per se is reasonable. My client's ability to meet the timetable became objectively impossible for reasons beyond its control.
Another issue that confuses me is that in your submissions and during your debate with Justice Majid, you said that the system was quick. And I don't know whether you even said it was good, but you said it was quick.
I think the word is used, it was swift and speedy.
Swift, yes. But you say it was not fit for purpose. I just find that a contradiction.
No, it's not with respect. My client's case is that the system, on an ad hoc, random basis, simply started to hang, or kicked you out, or refused to identify ID numbers, or reverted to the home page, randomly. When that wasn't working, when it wasn't randomly malfunctioning, it worked. It worked speedily, but the fact is it had these glitches. That's the very nature of a glitch.
Do we know what caused those glitches? Could it be your internet activity? As we're sitting in this court now, do we know if your internet was stable?
You are told, with respect, Justice Chiki, and the Electoral Court was told, my client hired a venue in the Sandton CBD that had secure internet access. It had up-to-date computers. The internet was speedy and reliable and stable, and that the people that it had selected to do this task were hand-selected by the deponent and had the necessary skills. There is no evidence before you contradicting any of that.
No. I think my question was directed at the time.
Yes.
The time in question, because as you know, it might be stable in the morning, but at some stage, it would be unstable and all of that. I don't have evidence.
No,
I'm speculating, and I'm asking you because I'm avoiding speculating.
I'm sorry for interrupting you, Justice. The evidence is that the glitching and hanging and stalling wasn't just confined to the 8th. It's something that started earlier. And that's why I took my client from the 21st to the 6th to deal with the submissions. So it was a repeating problem. And it's a problem that was experienced. The glitching, the stalling was all experienced by other parties. And it's common cause that they complain about the glitching. It's bizarre that they all use the same language. But the complaints are not limited to my client. So the probabilities is that there must be, and it's not just an inference with respect, the probabilities are that the problem must be on the side of the portal if everybody has the same complaint.
Mr. Am, thank you for your submissions. I first wanted to ask you, you've gone at pains to argue that there's no dispute of fact. I think we may find that there is a dispute of fact, and then generally the Plascon-Evans rule would apply. And I would just like to hear your submissions. There have been cases which have argued that in certain circumstances the Plascon-Evans rule is not fit for purpose. I referenced the case of Mahala versus Nkombombini, which dealt with a burial that was to take place the next day. And the judge in that case held that in favor of the applicants and essentially ruled that the Plascon-Evans rule was not helpful. And in academic commentary, Alan Dobson has said in the annual survey of 2006, implicit in the court's approach is that the recognition that the rule may sometimes cause hardship for the applicant and perhaps is maybe not even constitutional in certain circumstances. We are faced here with a situation of urgency of the hearing in front of the Electoral Court, where there's, as I understand it, generally has to take place on the papers rather than in relation to oral evidence being heard. In those circumstances, I would like to hear your submissions as to whether or not these circumstances may call for a relaxation of the Plascon-Evans rule.
We submit absolutely, and we make the submission on 3 grounds. The starting point is what His Lordship Justice Harms said in the National Director of Public Prosecutions versus Zuma case. His Lordship Justice Harms proceeds on the following basis. Motion proceedings, unless concerned with interim fact, are all about the resolution of legal issues based on common cause facts, unless the circumstances are special. They cannot be used to resolve factual issues because they are not entirely to determine probabilities. We submit that the circumstances here are inherently special. And the reason what makes them special is the following. My client was obliged to go on motion to the electoral court. Okay? It finds itself in a disadvantageous position because usually when you're dealing with statutory bodies in a, let's take a tender environment, and you follow a Rule 53 process, you call for the record, you get all the information that you need, you're then entitled to supplement your notice of motion and your founding affidavit, and that's your case. My client didn't have a right to what the Commission knew and what facts the Commission had. Yeah, it wasn't entitled to call for that. So all it can do is go to court on the little bit it has. It's not in control of the system. It's not possessing the information of who was able to do it and why, and how do you compare apples with apples. Because the only way you can compare another party with my client is to say, well, they had 121,000 supporters and 530 odd nominees. That's the only way. But the only custodian of that information is the Commission. So these are specifically special or exceptional circumstances, particularly of the type that His Lordship Justice Harms contemplated. But my third submission goes right back to the start of when I dealt with the dicta of His Lordship Justice Sachs. He says things must be interpreted in favour of enfranchisement rather than disenfranchisement. We're dealing with constitutional rights here, the right to vote. It's fundamental. And for my client to fail on a Plascon-Evans test, when it's disadvantaged because it doesn't have the information, and it's disadvantaged because the Commission doesn't put up the information, is with respect, applying the test in that circumstances is with respect unconstitutional. Because my client hasn't been afforded the right to a fair hearing.
Thank you for your submissions in that regard. A second issue that I worry is that at what point can we conclude that where there was no reasonable opportunity to comply with the election timetable? So I think we can have two extremes. If no party managed to succeed, it would clearly not, there would be no reasonable opportunity. If there was only one party that didn't succeed, you would perhaps think that the system was reasonably capable. And here we've got a strange system of situation where 65% of unrepresented parties succeeded and 35% didn't. I'd be interested to hear in your submissions of how we examine reasonableness in that in those circumstances.
This is a rephrasing of the question you put to my friend Mr. Loxton. Myself and my junior was debated it at the break. It's a very difficult question, but ultimately it's a question that can't be answered in a factual vacuum with respect. It can't be answered in principle, because where do you draw the line? It's got to be a fact-bound inquiry and an inquiry that's determined by the facts. It's impossible to say with respect. I submit. It may be that one person being precluded for issues entirely beyond their control, absolutely entirely beyond their control. Namely that the Commission had, let's take an example, had given the incorrect access code. That's a fact-bound inquiry, so it's very difficult, if not impossible, with respect to answer your question in a factual vacuum.
Okay, my last question relates to relief. I wasn't entirely clear from you and in your discussion with myself exactly where you were going with that. My understanding was that you had proposed relief that was not the most drastic version of the relief required. And so I'm wondering, is there a way to grant you an order, if we find in your favor, that would have relevance to your client, which would enable their participation without postponing the election?
Well, what we would certainly eschew is any declaratory relief. What we would certainly not want is declaratory relief. Sorry, you didn't make it, better luck next time, because that's ultimately what it would be. But as to what relief is to be granted and whether it's competent, the only person who can tell you with respect is the Commission. All we know is that the Commission tells us that for us to do what we need to do, assuming a perfect or a system that operates fit for purpose, an hour or two. Whether they can fill it in or not, we don't know. We're not in possession of that information. And that's why I'm sorry, I can only give you a vague answer. But we would certainly want to participate in the election.
Do you understand?
We'll take the lunch adjournment, but an abbreviated lunch for 45 minutes. We'll come back at 2 o'clock. We have finished with you, Mr.
Am I finished?
Yes.
So I can enjoy lunch.
You can enjoy your lunch.
Thank you very much.
Good day once more, let us be ready. Good day, let us be ready. Thank you.
It's your turn.
Afternoon, Justices. Yes. Yes, Justices, I propose to deal with three topics.
Carry on.
I propose to deal with three topics for our submissions. The first one will deal with the proper interpretation of Section 27, considering the text, context, and the purpose, and in line. I'm saying we tend to deal with the first point is 27, consideration of interpretation in line with common law principles of interpretation, and in line with Section 39 of the Constitution and other jurisprudences that are developed by this court. I'll then deal with the second question of a proper interpretation of Section 19, specifically also on the jurisprudence insofar as interpretation of the rights that are concerned. The third point that I then love to deal with probably at length is to demonstrate and persuade the justices that there are actually no material disputes of facts. It's only the question of law that ought to be determined by the court. So, in substance, first issue and the second issue, it will then encompass the so-called jurisdiction for this court to hear this matter in terms of Section 167. But before I proceed with my key important issues, I just highlighted to say that there's one issue that has been arising. It's that of opening of the floodgates in event that the court was to be with us in terms of giving us an opportunity to participate in elections. That question then find an answer. It's important for me to do with it. If justices would have a regard to Section 28 of the Electoral Act, purely from literal interpretation point of view, it's couched in a peremptory terms to say that IEC has got a mandate. Actually, even that one able to comply, then it comes a perimeter upon IEC to identify all those issues, identify why the parties do not comply and afford us an opportunity to comply. So it deals with that aspect of saying if was the issue for whether the election should be postponed or not postponed. That's another thing. So Justice, I humbly request that as we retire, consider 28 and in light of the discussions that are arising out of this country, consider Section 28 of the Electoral Act. The second preliminary issue that I just want to clarify and perhaps to outline properly, Justice, is my earlier life before I was called to the bar. I was in IT and computer, so I understand that language quite well. So I'll just have to demonstrate graphically how the system works. and to demonstrate that it's from a graphic point of view, from a sequence point of view. So how the system works, so ordinarily, in terms of the IEC, in order for one to qualify to contest for
Are you giving evidence from the bar now, Mr. Rabayiti?
No, I just wanted to just outline this. IEC has covered the thing. I just want the system,
in
how
the
it works.
papers.
In the IEC's answering affidavit, they dealt with the system.
Alright.
So it's important for one, because what becomes crucial issue in the system is to understand the system, to say the starting point. The starting point, it's manual submissions of the members of the organization. You punch the IDs manually. Then the system will then automatically generate to check whether you qualify or don't qualify. It kicks it out. That's a manual submission, the starting point. Then once then it's done, it will then move to the second scenario where you do what you call a bulk submission in a form of a thing, in a form of an Excel. So it's very important that you understand, the more you outload, then the system then it will then generate automatic. So it's not something that goes. So once you punch the IDs, then it verifies that either they will be kicked out, others, I'm just doing an overview from a general point of view just to understand. So if then the IDs, then it kicks you out, others will it will admit, others will kick them out. Once those are then verified, then it moves to the second stage, which then we call it a bulk submission. So those that are verified, then you then populate it in what you call a spreadsheet or Excel. Then you upload it in the form, the second stage. Once then you done the second stage, then it then give you what you call that invoice, the payment, to say that, all right, I see that you qualify. Therefore, it generates the payment. So the payment, then you then do the payment. After subsequent payment, that's when you can upload the last stage, your contestant, where they're going to. So in the olden days, just to remember, we have a national assembly, we have a provincial assembly, then provincial legislature, and we have provincial council of provincial provinces. So historically it should be called like that, but now we call it regions. For the purpose of the new language, it's called regions. So depending, so if for instance, you want to contest national, of course it says that you need to have 13,000 signatories. So if then you'd say one region, for you to contest, let's say, so the NCOPs or the provinces are regarded as regions for the purpose of elections. So if you qualify for the Free State, let's say for instance, your 4,000 signatories, then automatically it will tell you qualify. So it's in stages, just like that. So that's how the outgroup of the system it is. So that's how the outgroup of the system it is. So I'll then demonstrate in the facts that are unique and peculiar to us as ASD, that we complied, strictly and substantially compliant within the definition and the meaning of Section 27. When you consider it from text, context, and purpose point of view, I'll demonstrate. Now, let's then deal with the issues of the facts. Now, if then I was to take you to the facts that are unique to us as ASD, it's a common cause that we didn't start. We started as early as the 28th. Even IEC concede as early as the 28th of February 2024. Uploading of the signatories, of course, it didn't take quite a long. It took a couple of days for us to upload the signatories. So insofar as what 27 requires, so when you consider 27 purely from a linguistic point of view, we qualified in terms of uploading of the signatories of our supporters. That's number one. Number two, then the payment was then generated before before it kicks it out. So on the second scenario, also from literal literal point of view, we qualified within the Section 27 what 27 says. Now, what becomes crucial where I'm saying it's a mountain to climb, but it's worth persuading the court that you agree with us. So when it then came to our candidates, we submitted. I can refer to the IEC's papers. We then, when it came to our candidates that we participated, we uploaded. Regrettably, unfortunately, we didn't. In the proper language of opponents, it's we didn't click that finish button. That's the crisis that as we're sitting in the portal. So from a manual point, it's like if we were to submit, if we were to rush it, if we were to have been submitting our things at IEC physically, one would say that we walk in, but we're in between the gate and the door. So on that basis, I make a proposition that it's a common cause fact. So on a proper compliance of Section 27, we did comply. We were just unfortunate because we were sitting in portal, we didn't click that finish button. So those are the facts that I wanted to canvass to say that from a factual point of view, we complied. Now, I want first to deal with the first point of Section 27 of the proper interpretation, because my learned colleagues had advanced certain factual issues at length. The question of law was not dealt with. Just as in our heads of argument, we quoted a case of whole ideas in this court. We decided that interpretation of a statute, you need to consider the text at first, consider the purpose, the text within the context and the purpose, and most importantly, consistent with the Constitution. What it really says is, when you're looking at Section 27, of course, from a textual point of view, it's quite clear. It says that you must submit and comply. Within the context, when you look at it holistically, between context 27 and 28, is we need to comply. Even if you didn't comply, it becomes incumbent upon the IEC to notify us that we didn't comply. So when we look at 27 from the context point of view, it's that it cannot be read in isolation. It has to be read within 28. So it's on that basis I'm saying that from a contextual point of view that we complied. I'm simply saying this on the narration of the facts that I've referred to. So if you were to consider our facts uniquely, they fall within the parameters and the definition of Section 27. And then also the whole purpose of Section 27 is to afford us an opportunity to be able to participate in the elections. So insofar as 27 is concerned, Justice, the point that I want to make is, I've demonstrated that we paid 350,000 that was required. We submitted the signatories. Our candidates, even the report there's where they say in the Free State we qualify. So our facts fall within the ambit of Section 27. Safe to say, whether we're sitting there we're in between the gate or the door, but we are in. So it falls within the parameter of Section 27. So also from a purposive point, from contextual point of view, we're saying, even if let's say IEC says, all right, we cannot condone your non-compliance as the defense, or they don't want to tamper with the timelines. But 28, it's couched in the deliberate choice of the language that we check. It's couched in a parameter to say they must inform us. So on that basis, on that basis, I make a submission that we did comply. Justice, of course, there's a case that actually the most recent case that appeared before you in Makate versus Borako Marine Campus, but of course that case was dealing more in the context of prescription and apparent prescription on a civil authority. But what becomes important in Makate, insofar as an interpretation, the jurisprudence that this court indicated in Makate, was that if there's an infringement of any rights protected in the Constitution, in this instance, we're talking about Section 9, what Makate said, it becomes incumbent to interpret legislation within the presence of time. It takes the role of the cases, there's Undai and others that came before. So all I'm just saying, Justice, I'm saying, even if we were to consider it, it then becomes incumbent within the jurisprudence of Makate to say, all right, we didn't comply, but it becomes incumbent to consider, because the right at stake, it's Section 19, so it's important for one to consider 27 within the prisms of the Constitution. That's another point that I just want to make. I don't want to dwell a lot in terms of interpretations of my learned colleagues have dealt with it. Now, if then I then move to our second point, that of Section 19. Section 19 becomes a very, very important right. Understand the history of our country. The thrusters of the Constitution were quite clear why there's a need. That's why you then consider, when you consider the founding provisions of our Constitution, adult suffrage is quite clear. What this court said in the first, one of the earliest jurisprudence in the case of State versus Zuma, then was followed by Makwanyani, which then dealt with the proper interpretation of the Provisional Bill of Rights. It provided what we call a two-state approach when you're dealing with the provision of the Bill of Rights. As an applicant, I need to demonstrate that one's right has been infringed. That's the first stage. If the court is then persuaded, and then it becomes upon the IEC to demonstrate that that limitation is reasonable and justifiable in an open and democratic society. That's what second phase comes upon the proportionality test and the likes. But what becomes crucial, Constitutional Court said, what becomes crucial, this court said, you need to consider it purposively and generously. Those are the two important aspects that you need to consider. So it says that what is the most important purpose of Section 19? It says that consider the purpose of that right that it needs to protect, why it was enacted, and consider the history of this country. It's quite clear, it's quite evident that majority of South African citizens were actually deprived of voters' rights up until 1994. So that's why from a purposive point of view, it becomes incumbent for members of organization to be afforded to vote for the organization of their choice. So they cannot be disenfranchised because of the system that, well, I know that I didn't click okay, but from a purposive understanding point of proper interpretation, the submission that I want to make is, when considering the history of the Republic of South Africa, majority of all people were disenfranchised. Number two, it's for them to be afforded an opportunity to choose those that who they want to elect within the meaning and definition of Section 19. But other than them considering generous interpretation, it's quite broad, justices, in the sense that it says that you need to allow individual citizens, those that are voting or those that want to participate in the election, to be voted in, to enjoy that fullest right. So that's where we are currently. We are saying, IEC says, it's your own misfortune. I closed the it was only for misfortune. All right. Let's say, for instance, in that case alone, that my unfortunate that I was unable to claim. But they avoid Section 28. That tells them that no, regardless of the fact, whether you have timelines, whether you cannot condone 28 priority, it says that inform us, inform the applicants why couldn't it then apply, and it gives them stages that they need to do in order for them to participate. So those are the points that I don't want to do further, that I wanted to make submission in relation. I'm partially then open for the questions. So the points that I want to make for the closure is, one, I've referred you to the Section 28 to say that consider it for the purpose of the thing, of the question that the opening of floodgates of heaven, floodgates of other organizations in such a way. The second point, I say 27, consider 27 within the text, context, and the purpose and the proper interpretation. I've seen the IECs avoiding. What IEC done, they've adopted the so-called, the so-called literal interpretation. They just said, 27, non-compliance to 27, you're out. So consider Section 27 when you look at within the text, context, and the purpose, we complied. And the third point that I also want to make is, even if the court was unable to agree with me, it's incumbent, I make a submission that the third point, that consider Section 39, Section 39, subsection 2 of the Constitution, when because the right at stake, it's one of the most important rights And also the fourth point that I also want to make is it does not necessarily raise material disputes of facts in the sense that IEC also has considered to say, all right, we are all on misfortune that we are unable to click, and as a result of that, all the processes that we did were followed. I don't want to canvass a lot because our learned colleagues have actually canvassed the most important points. So I'm open for the questions, just as a suggestion.
Thank you, Mr. Omoiti. Can you just, for my own edification, explain this to me? Do I understand your case correctly to be that the fact that your client was locked in by a deadline, 5 p.m., is enough? That complied with the requirement, even though it locked in literally a second before 5 o'clock?
That's my submission, but can I answer like this, Chief Justice? When we consider 27, the method that IEC deliberately chose, it said that you must submit electronically. So when you consider 27, all of those things we submit. So to answer, yes, we comply regardless of the timelines. That 5 o'clock we couldn't make it, so we comply within Section 27.
And how does Section 28 assist your client?
28 may perhaps, so 28 is causes as follows. The heading is non-compliance concerning submissions of the list of candidates. Subsection 1, I will only read subsection 1. Subsection 2, subsection 2 specifically it says, if registered parties has submitted a list of candidates and has not fully complied with the section 27, subsection 2A and 24, electoral officer, the most important, must notify the parties for non-compliance. So it's in parameters. So it assists me that if I'm not complying, it becomes incumbent upon IEC to have informed us immediately that it did not comply. That's number one. Number two, it says the notification must be given in a prescribed manner, but not later than relevant dates stated in the election timetable. So how it assists us is, all right, I may not have complied, but IEC tell us that we do not comply and give us an opportunity for us to rectify. Because on that basis, that seems 28, it assists us in these instances.
And which date would the date mentioned in subsection 2?
Subsection 2, it says, it says the notification must be given in a prescribed manner by not later than relevant date stated in the election timetable. And must
which date would that have been?
I would presume, I presume it would not necessarily, in a strict sense, it cannot be the 8th, which is the time deadline. I presume it may be even the subsequent date after the date of the question of the submissions. But how then would IEC be able to notify that we didn't comply? It would only have been after the 8th. It would only after the 8th that we didn't comply. Then after the 8th, then we didn't comply. Therefore, for it not to be disturbed with other dates, it can be any day after the 8th, Chief Justice. That's the point that I just want to make.
And your client no longer relies on load shedding? Load shedding
well, it's holistic. On the aspect of load shedding, it's not that the point that we want to make, of course, and that day there was a schedule of load shedding in the sense that it affected us for further submissions. But regardless of the fact that even if when it came, they were still able to proceed with the things of manual, of all electronic submissions of candidates. It's part of it, but the primary aspect of it is that one of us kicking out at the timeline, of kicking us out of the
how does then Section 28 come in? Because has it been technically submitted or fully submitted? If it's not in, basically, it doesn't look like the list was submitted.
So how does Section 28 comes in? Let's say in a worst case scenario, I did not substantially comply. It's incumbent upon me to comply in terms of 27. As an applicant, I need to comply. That's so far as I have to do in terms of 27. Then it comes incumbent upon IEC at 28. IEC then must inform us within the meaning of 28.1 and say that applicant did not comply. So that's where the IEC then comes from to say comply. Then it says, the language says, registered party that has submitted a candidate who is not fully complied in terms of 27. The chief electoral officer must notify that party. So it comes incumbent upon the IEC then to notify us that we did not comply to this. So it's on that basis I'm saying 28, it then assists us for the purpose of non-compliance of 27.
I'm looking at the timetable, para 10 thereof, or item 10, that says cut-off date for notice of non-compliance by content states in respect of lists. It says the chief electoral officer must notify a registered party that has submitted a list of candidates in terms of Section 27, but does not fully comply with Section 27 2A, B, C, A, and G, or 27.4 of that non-compliance by 18 March 2024. So the first question is the submission part, the list must have been submitted.
Yes.
Now yours was halfway. The halfway part, can one then say it's submission or what? Because it has to be submitted before the CEO can then notify a party of non-compliance.
So the sensible interpretation would be in terms of 27, sensible interpretation is our support had to submitted. The system allowed us to pay, we paid. We then submitted candidates. Even though some were successful, others were not. So sensible interpretation would then be as qualified in terms of 27. Whether it's a strict or substantial, it's a different scenario altogether. Because IEC then even the portal then demonstrated that indeed the other complied, substantially complied. So what the OP have done in terms of 28, in terms of the calendar, OP have told us it's nothing that they've done to us. They've never told us anything. So to answer, yes, it's supposed to have told us I think 28 that we did not necessarily comply. That would be the sensible interpretation, Justice. I would say the ought to have been done. But as we spoke, IEC never notified us that we didn't comply. Whether it's a strict or substantial.
Do I understand the relief that you seek? Do I understand it correctly that you seek an order that you and you alone be permitted an extra window period to do what has been done?
That will be the prayer that we just to submit. Yeah, that's the prayer that we, if the court was to agree with us, that's the only issue that we request, that we give an opportunity to submit the remaining.
This court has said in a number of judgments that the commission must be even-handed. The commission must be seen to be to treat parties equally. So you can't make special indulgences for some and not for others.
Just as hence I indicated in our, I said, all right, if, for instance, I'm defeated, we are defeated on commission give us an opportunity to supply. But as a matter of law, 28 informs them for them to afford an opportunity to tell us why we didn't comply, then we were able to comply. So as a matter of law, we need to be notified. As a matter of law, we need to be notified, and then we deal with the defects of non-compliance. So on that basis, I hear what the court is saying, that we need to be present. So if you are to strike a balance, let me look at an analogy on the proportionality. It's at 27, 28 gives an opportunity for us to rectify the defects that we have in 27. So it wouldn't necessarily be open in the front of it that allowing other parties to be given opportunity. So it's on that basis I'm saying, on the matter of law, we can be assisted by 28.
Let me read you what this court decided in the Liberal Party about Section 28. The Liberal Party judgment in paragraph 22 says the following. Section 28(1) provides for condemnation and rectification, and here comes the important part. Quote, let me read further, that's just in brackets. Quote continues. As such, contrary to the applicants, that's the Liberal Party submission, Section 28 does not vest the Commission with the discretion to condone late submission of candidates' lists, but only to allow the rectification of other failures to comply with Section 27. The applicant had not submitted a list by the deadline and is therefore not entitled to rectify its non-performance in terms of Section 28. How is your case different than that of the Liberal Party in this case?
It's quite clear. As we were on time, we were within 28 on the 8th. We are not out of time, we were within time on the 8th. It was only that.
No, I don't understand. Let me just clarify this. One of the parties says by the time the deadline came at 5 o'clock, I think it was the Labour Party, all the stuff were in boxes. You say your stuff was in the computer. That's not what submit means. What does submit mean? It's like saying the check is in the mail when we still used to write checks. You haven't paid until the check is on the other side and it's been deposited.
Just would you allow me to talk a computer language? I think probably it's important for one to clarify from a computer language point of view.
I hope I can understand.
With the greatest respect, so deadline. Let's talk from a manual point of view. Answer in 2 ways. From a manual point of view, it will make logical and sensible sense to say that we're supposed to have been there at 5 o'clock manual. It could not. It's a different situation. I understand. Now let's come in this scenario. IEC chose electronic submissions. So at just before 5 o'clock cutoff, the names were already uploaded in the system. They already uploaded in the system, so they will be sitting somewhere in the cloud of the IEC. So to answer that question, yes, we're within time. It's only that we're only supposed to just do a last stage, then the system kicked us out. So it's not a scenario where we are saying that the system 5 o'clock came, then you wanted to submit after 5 o'clock. It's not the case that we're trying to make. So to answer the question is that our names were sitting there in the portal for the purpose of them to do. That's why they were able to, in the printout, that's why in their own printout, they're able to see that indeed others were qualified, others were just out of time.
Can you take me to your papers, your founding papers in the electoral court, and show me where you refer to this clicking, where you were supposed to click finish and it kicked you out? Where is it in the affidavit, please? If you can't find it now, we can always get back to it later as my other colleagues proceed. Maybe your juniors can check in the meantime. But if you can't put your finger on immediately, you can park it for later. Just remind me to come back to it though, because I forget. Can I ask you something else? Did you bring this review in the electoral court in terms of partner?
We sought a clarity order.
Well, let me backtrack. Sorry, I was one step ahead. Did you bring a review application?
In substance, it was a review application.
So, what is the decision that the commission took? Where do we find that decision?
So, just a minute. Let's talk about the jurisprudence of administrative action. I think it's important.
No, just show me in the papers or in the act, in the electoral act. In the papers. Where's the decision?
I just wanted to demonstrate that issue. The submission was done electronically. It's not manual. So for the fact that the system kicked us out, one probably from a persuasion point of view, you would say that purely from a persuasion point of view, for the clicking, for the system to kick us out, purely from a persuasion point of view, I would say that one would, even if I may not necessarily have an authority in law, but from a persuasion point of view, I would say that the kicking out would then follow through the parameters and the definition of administrative action. I don't have an authority, and merely persuading to that, so that would then, those will be the decision, electronic decision that have got direct and external legal effects.
Hang on, maybe I'm just being obtuse, but explain to me. See, the reason I'm asking this is PAJA, as you know, in Section 1 defines what a decision means. So what is the decision here, and where do we find it by the Commission?
Just much, I'm too liable. I don't want to create dialogue with you, but with great respect. So, the choice, IEC ordinarily decided that submission must be done electronically. That's number one. So, PAJA is quite clear. Let's say definition, the definition of PAJA decision has been only confined
Okay, now I understand you. Sorry, I missed
to the decision. So,
Sorry, now we're on the same level. Let me ask you this then. Two things. Firstly, it wasn't just electronic submission. You could also deliver physically, except for the signatures which had to be scanned and so on. You could do it physically. You will accept that?
but the only office that was only allowed was when the Free State. So the only office that was allowed was only National Office in Centurion. Yes, we could have developed, but logistics strictly at that time it dealt with us because of the distance from Bloemfontein to Centurion.
Now that decision for it to be made either online or physically only at the head office in Centurion, that decision was made in terms of regulations. Do you accept that?
I do accept that.
Have you challenged the regulations?
We didn't really challenge regulations because the issue was not necessarily about either the rationality and reasonableness of the thing, of the regulations. It was merely to say that, just declare that, afford us an opportunity to finalize our submissions.
You see, Mr. Awaiya, how they work is like this. They look at the act and they look at the regulations and they work out how they're going to do these elections, the run-up to it. And so they pass regulations as subordinate legislation to say, we would like to have these things done electronically or physical delivery of their office. That's the fount of the foundation, the origin of their decision then to pass an item 9, a deadline for submissions. So surely you got to challenge that. The origin, the regulations, the act, and it's unchallenged. Or even the election timetable. But that is not your case. It wasn't your case in the electoral court, right?
Can I say something? In the language of agent court in the lower courts, it was in such a way that extreme, at that time when they prepared the papers, so at the time when the papers were prepared, the issue was only another issue for allowing us to make our submissions on the portal. So that's one of the challenging of the thing of the regulations was not one of those things that we considered.
So are you saying now that your case isn't that the portal didn't work? It was the choice they made for how you should submit?
Our case, it's as a result of one, I indicated one. So from a sequence point of view, what will then happen is, let me deal with the first stage. The first stage that you submit, then it will then generate a report. So because of the delay of generations of the report, and also our submission, the bulk submissions, it didn't assist us to be able to click on time. So that's a submission that I just want to make insofar as this process. I don't know if I was able to answer your questions.
See, Mr. Awaiya, I think what happened here was you misunderstood how the process works. You thought that you first had to upload all your signatures and do the payment deposit before you could do the candidate submissions. I think you said somewhere in your papers in the electoral court, you said that the OCMS is designed in such a way that in order for the unrepresented party to create payment reference and make nominations, that's the candidate list, it must first comply with section 27(2) small c capital B 1 and 2 of the Electoral Act. That is the uploading of supporters. And that's wrong, isn't it?
I may not necessarily, our understanding of the system as it was designed, we understood that you move from one stage, then once you're done with another stage, then it allows you to open the second stage. That's how we then understood the system to be okay.
Well, all I'm saying to you, it seems to me it was a misconception. All you had to do, as I understand it, you decide which of these basically 10 elections, one National Assembly and 9 provincial legislatures I want to participate in. You then ticked it on the computer, and there's generated a payment reference. Once you have that, you can do all these things simultaneously. You could do supporters upload signatures, you could do candidates uploads, and you could start doing this as early as 23 February, if I understand it correctly. Not so.
We could, but we also have done that. From a sequence point of view, we started as early as February, all the sequences moving up until the last day, the 8th. That's what we actually did in our case. And IEC also conceded to that effect that we started as early as February, doing all the processes. But I hear what the court is saying in the sense that we would have made a payment, we would have done them at a go. But the challenge would have been the first stage where it requires verification of the IDs. That's the one that we not necessarily allowed to the public. Then from Excel, even for product, that's the one. But the initial one, that's a romantic one that allows you to punch the IDs manually, then you wait for.
You see, it seems to me you're still laboring under misapprehension. There's no first stage, second stage. The only first stage really is to generate a payment reference. And then you could do all these things all at once. You could even do it offline, prepare Excel spreadsheets, and then upload it on the system just once and for all. But it seems to me you're still talking about you first had to upload all the supporters and signatures lists before you could do the candidate lists. That is not how it worked.
I can't take it any further than the submissions that I've made.
Yes, thank you, PCC. Thank you.
Thank you, Mr. Romeriti. We have no more questions.
That's concludes my submissions.
Mr. Bishop.
Thank you, Deputy Chief Justice. Sorry, DCJ, I understood that I was getting 1 hour uninterrupted. Perhaps I misunderstood.
Okay, we have said 45 minutes, an hour. You want an hour?
I would like an hour.
We'll give you
Deputy
an
Chief
hour.
Justice. I'll try and be less.
Okay.
Thank you. One hour 45 is fine.
No! Okay.
Thank you, Deputy Chief Justice. The question in this case is, did the Commission provide a submission system that a reasonable political party could use to nominate candidates by the deadline? And that's a question of fact. On one side, you have objective evidence from the Commission that the majority of parties, and I'll come to the vast majority of parties, were able to successfully use the OCNS to submit candidate lists, supporter signatures, supporter information. We have objective evidence from the Commission's IT experts that confirm the system was working. We have evidence about what happened in the last half hour before the deadline closed, showing that thousands of supporters were uploaded and hundreds of candidates were uploaded. On the other side, what we have is subjective complaints. To say for us, it didn't work. We experienced difficulties. But the reality, if one looks at the facts, of each of these cases, the true explanation is that the system worked, but the parties didn't. They had enough time to use the system. They had more than adequate training to know how to use the system. But they underestimated the task, particularly the task of submitting the supporter signatures and information. They made mistakes. They didn't understand how the system worked, despite the training given by the Commission. They failed to take advantage of the system that allowed them to have multiple users simultaneously, that allowed it bulk uploads instead of manual uploads. And ultimately, they left compliance too late. And that's why the Electoral Court held that on the probabilities, the OCNS was not as ineffective and cumbersome to use as the applicants would make it out to be. It follows that it was, as alleged by the Commission, the applicants' unpreparedness and their tardiness which resulted in their inability to comply with the provisions of Section 27. The Electoral Court reached a similar conclusion in two similar matters in a case decided on Monday, Arise South Africa. Of course, it is unfortunate that these applicants, that these parties will not compete in the elections. It is unfortunate that their supporters will not be able to vote for the parties they want to vote for. But the reality is, in order to have an election at all, there have to be rules. And the Commission has to enforce those rules. And the reality is that those rules will mean that some people do not comply. But that does not result in a limitation of rights. There's only a limitation of rights if the Commission failed to afford reasonable parties an opportunity to comply. So, with that introduction, I intend to address the following topics. I want to start by just clearing the weeds and getting a few issues out of the way. I'm then going to deal with what is the case for this court, what is the legal standard, and what is the factual standard, and the application of Postpone evidence. I'm then going to set out the Commission's positive version of the evidence that shows the system work positively. This is not a case where the Commission just put up a bare denial and just denied the allegation that the system didn't work. It puts up positive evidence to show functionality. I'll then deal with the applicants' versions and why they do not create, either on the probabilities or applying Postpone evidence, show that the Commission's version is far-fetched or clearly untenable. I'm going to do that thematically, looking at all three parties. I'm then going to deal with each of the applications in turn and go through the Labour Party, ACT and AASD and deal with their specific facts and the specific issues that arise in each case. I'm then going to deal with jurisdiction and finally with remedy. So to begin with, just clearing some weeds, I think it's important to be clear about what the case is not about. So this case is not about the legality or the fairness or the reasonableness of the supporter and signature requirement. This court held in One Movement South Africa that it was an onerous requirement for independent candidates, but it decided to leave it in place for unrepresented parties for this election. That is the law. It may be that in the future this court decides that requirement is unconstitutional, but for the purposes of this case and this election, it is a constitutional law. It's also not about the requirement that candidates' details must be submitted online or only at the head office of the Commission. In many, we didn't hear it today in oral argument, but in many of the affidavits and heads of argument that are being filed, there's a complaint about this, that it's unfair to require parties to submit it online. But that issue would only be before this court if there was a challenge to the regulations. The fact that you can only physically submit in Centurion, that, whether that is lawful or not lawful, would only be before this court if there was a challenge to the regulations, and there is no challenge. This case is also not about the digital divide that the minority of the Electoral Court mentioned in its judgment. The issue was never pleaded in the Electoral Court by any of these parties. Indeed, these parties all say they are very tech-savvy. They're on the right side of any digital divide. And in any event, it would again require an attack on the regs that establish the OCMS. This case is also not about the importance of the rights in Section 19. Mr. Am gave a very passionate reliance on those rights. And he's right. These are vital, central rights for our democracy. But as I'm going to submit, those rights are defended by what the Commission did in this case, by establishing a reasonable system and holding parties to that system. It's also not about the tone that the Commission adopted. Mr. Am took issue with the tone and the approach of the Commission, and I think those attacks are unfair. He complained that the Commission said that these parties had failed to comply. Instead, it was objectively impossible for them to comply. But that's a whole debate in this case. That's the debate between the parties. The Commission says they failed. They said it was impossible. It's not inappropriate for the Commission to use that type of language. Nor is it fair to say that the Commission has withheld any type of information. We have given the information that has been requested. The Commission had to respond to, at current count, I think 12 similar applications. Each one of them had to be responded to within a couple of days in the Electoral Court urgently. And the Commission has done the best it can to put up as much relevant information as it can in each application. So really the case is only about one thing: whether the Commission provided a system which a reasonable party could have complied with. In my submissions, I don't intend to distinguish between whether this court should refuse direct access, refuse leave to appeal, or dismiss the applications on the merit. The Commission's position is that it should refuse direct access, and it should dismiss the applications for leave to appeal, because there are no prospects of success, and it's not in the interests of justice. But I'm going to address the court on the basis that the cases are before it on the merits, and just address the court on the merits. So that gets to what is the legal standard for this court? What is the test? And the case, it's being presented differently by different parties and at different stages. But I think really what the case is that the Commission limited these parties' Section 18 and Section 19 rights because its conduct, the way that it supplied the OCNS, or the way that it managed the OCNS, made it objectively impossible for them to comply with the requirements of Section 27 by the deadline. And we agree that's the correct form of analysis. And we know from One Movement South Africa that in this type of situation, there's two types of cases. There's a type of case like One Movement, where Parliament enacted a law that actively restricted the ability to stand for political office. And that was the intention of the signature requirement for independent candidates, to make it more difficult. And there the law, the conduct, just because it makes it more difficult, limits the right. But there's a different type of case, the case that was at issue in the New National Party, which is where the government, through law or conduct, gives effect to the right to vote or the right to stand for office. So New National Party, the requirement to have a barcoded identity document was a step that this court held was necessary for the realization of the right. Because in order to have free and fair elections, you need to ensure that only people who are on the voters' roll vote. And this is that type of case. Because there's no dispute in this court that the OCNS is designed to facilitate participation and management of the election. So it was adopted initially to help political parties to get around the difficulties of physical submission by ensuring that parties could submit 24/7 from anywhere in the world. And it also assists the Commission in its management of the elections, because it allows the Commission to check in real time as parties put up ID numbers of candidates or supporters that they are on the voters' roll, the correct segment of the voters' roll, that they're still alive. And it alleviates the massive administrative burden that the Commission faces, and is significantly higher with the new Section 27(2)(c) capital B, the supporter requirement, of taking all that physical paper and then collating it and checking, going through it and checking each supporter, the 47,000 supporters each party needs to compete in all the elections. So if it received all that in paper, it would have to go through every single one of them and check that that person is a valid vote on the right section of the voters' roll. And so all of this is designed to facilitate a free and fair elections. And so then we get to the test, and it's said clearly in One Movement South Africa, paragraph 258A, where the court says, where impugned law or conduct gives effect to the exercise of a right to vote, it only limits the right if it is shown that its probable consequence is that those who want to exercise the right will be unable to do so, even though they act reasonably in pursuit of that right. So we have to show the probable consequence, so those who want to exercise it will be unable to do so, even if they act reasonably. That's the standard in this case. And the court in New National Party recognized, this is at paragraph 20 of New National Party, that any scheme designed to facilitate the exercise of the right to vote carries with it the possibility that some people will not comply with its provisions. But that does not make the scheme unconstitutional.
Sorry, Mr. Bishop, what paragraph is that? National
20. So that's the legal standard here. Then we get to how should this court resolve the dispute of fact? What is the role of task on evidence? And the case, I'll get to this in some detail when I deal with each party, but the case has narrowed quite considerably from what it was in the High Court with the Labour Party on the 8th of March, when we argued the case in the Labour Party, in the High Court, through the Electoral Court to this court. As I understand the focus of both the Labour Party and ACT, their primary complaint is that on the 7th and or 8th of March, the OCNS was not operating correctly. That prior to that, it was working smoothly, but on those days it wasn't working properly, and therefore it was impossible for them to comply. That is a question of fact. Either it was working or it wasn't. And it should be resolved according to Postpone evidence. The Commission's put up a version, which I'll get to, about showing that the OCNS worked. And the applicants can only succeed if they can show that the Commission's version is so far-fetched or clearly untenable that it should be rejected out of hand. I'd like to address Justice Bilchitz's question about the possible development of Postpone evidence. And we said it's not appropriate to develop it at all, and definitely not in this case. This court endorsed Postpone evidence for the constitutional disputes in the rail commuters case. The electoral court has repeatedly endorsed it and applied it in election disputes. I don't have all the cases with me, but in front of the electoral court, we put up a list of, I think, 5 or 6 cases in the electoral court where it applies Postpone evidence. And this court has applied it in a directly analogous matter, which is the Democratic Alliance in Re Electoral Commission of South Africa versus Minister of Cooperative Governance. The citation is 2021 ZACC 30. And that was a case that followed on the COVID postponement case. So after this court refused the Electoral Commission's request to postpone the 2021 local government elections beyond the constitutional date, the Democratic Alliance, I was then acting for the Democratic Alliance, approached this court to complain that the Electoral Commission had reopened candidate nominations, and it said that this court's order only permitted the reopening of voter registration, not candidate nominations. And it said, it accused the Electoral Commission of bias. So what this court said at paragraph 40, it said, in short, the DA alleges that the Commission's decision is biased and improper, and is inconsistent with the even-handedness demanded of an independent electoral body. The EFF alleges that the ANC will be disproportionately benefited by the extension of the cutoff date. It is not possible, however, on these papers, and in conformity with the Postpone evidence rule, to reject the Commission's denial of these imputations. So this court's applied Postpone evidence in an electoral case about candidate nominations. The case that Justice Bilchitz referred to, Magala versus Kombombini, is again, it's really an application of Postpone evidence, because what happened in that case is that the applicant's version was corroborated by confirmatory affidavits that there was a customary marriage. The respondent just put up a bare denial. And in those circumstances, Erasmus J. held that he would adopt the version of the applicant. But that's not a departure from Postpone evidence. The cases from Whiteman and so on, they say if you just put up a bare denial, that doesn't create a dispute of fact, particularly if the version of the applicant is corroborated. So there's no need to change Postpone evidence for electoral disputes, and it certainly shouldn't be done in this case, where the issue has not been argued by the parties. And in any event, I'll submit that it will make no difference, because the alternative to Postpone evidence is deciding it on the probabilities, looking at the affidavits and deciding what's more probable. If you do that on these facts, you will still reach the same conclusion as the electoral court. So against that background, what the test is, did the Commission create a system that a reasonable party could use to comply? And bearing in mind the Postpone evidence test, I'm going to turn to the Commission's positive evidence. And there's 6 forms of evidence that I want to go through. The first is the time that the OCNS was open. The second is the training that the Commission provided. The third is the functionality of the OCNS. The fourth is the success of other parties using the OCNS. The fifth is the lockdown IT report. And the sixth is the activity in the last half hour. So on the timing, this is set out in the heads of argument, so I don't want to belabor it. But the important point is that parties knew from April 2023, unrepresented parties, that they would be required to submit large numbers of supporters' information and signatures, because that's when the amendment was made to the Electoral Act. The Commission opened the OCNS to allow parties to begin uploading that information on the 26th of January 2024, so that's 42 days before the deadline. It opened the OCNS for candidate nominations on the 23rd of February, which is 14 days before the deadline. And the reason it had to wait is because it had to wait for the proclamation of the election by the President. So, and parties also knew from 2019 that there was an election coming sometime between May and August this year. So they knew roughly when the election was going to be. And ultimately, the deadline of the 8th of March was dictated by the election date. Because the Commission explains in its affidavits that through its experience, it's realized it needs at least 86 days from the date of proclamation to the date of the election. And it knows how much time it needs to do to perform each step. So the 8th of March date is set based on the time it needs after it receives the candidates to go through the process in section 28, 29, 30, and 31, deal with all the objections, notify parties to deliver further documents, so that it can ultimately finalize who's on the ballot and who's not, and it can print those ballots. So the first question is, did the Commission give parties enough time? And the answer is yes. The second question is, did the Commission do enough to assist parties, to explain to them how to use the OCNS? There's some allegations in the papers that this is the first time the OCNS is being used. That's not the case. It was used in the 2019 national election. It was used in the 2021 local government election. It's been used in by-elections since then. What's new is the signature requirement, because this is the first election in which that signature requirement has existed. But the OCNS has been used since 2019. And the Commission took multiple steps to inform particularly unrepresented parties, because represented parties should know how to use it, they've used it before, but particularly unrepresented parties, how to use it. So they held a training on the 29th of January for all unrepresented parties. ACT and AASD were present at the training. The Labour Party wasn't, because it had not yet completed the process of registering as a political party. It held 4 workshops in February and early March, different places across the country. Both the Labour Party and ACT attended those workshops. It produced multiple guides, help guides, explanations, which are all in the papers, which I invite the court to look at. I don't intend to take you through them, but they show step by step, with screenshots of the system, how to use it in extensive detail. The Commission's officials were also available on email, WhatsApp, and by the phone, and applicants made use of this. There's 2 good examples in the Labour Party case. When Mr. Janssen van Rensburg was trying to register as an OPA, he initially sent the notice, then you get a verification link, and you have to confirm it, so we can confirm your email is correct. And you have to do that within 24 hours. He waits too long. He then writes back on a Saturday to the Commission's officials and says, "Oh, it hasn't worked, please help." And the Commission's officials are helping him over a weekend. On Sunday, the 3rd of March, at 16:45, he sends an email to the Commission saying, "I'm not able to use this particular function. This isn't working for me." The Commission replies at 18:43 on a Sunday, 6:45 on a Sunday, 2 hours after receiving the message, explaining what the problem is. He was using the wrong tab. And he responds at 18:49, "Now it is working, thank you." That's PSM 18 to the answering affidavit in the Labour Party case. So did the Commission do enough to train, inform, and assist parties? Yes. The next question is, was the OCNS itself as a system functional? And I'm not going to go through everything, but I want to highlight certain elements that have come up in the debate. The first is that the OCNS allows multiple users. The Patriotic Alliance, Justice Manjit mentioned, had 189 users. And the idea was that you could have different users working on different provinces, different elections, or some could be doing candidates, some could be doing supporters. You could have as many as you like. And once you had an OPA, an online portal administrator, he appoints the users. You can just do it yourself. You don't need the Commission's intervention. You just appoint the additional sub-users. And then they can all be working in parallel. So the number of users you have is a bottleneck for how efficiently you can use the system. And it's something over which the Commission has no control. It cannot dictate to parties how many users they use. And in this case, Labour Party only had an OPA, had no sub-users. ACT had its OPA at 1 sub-user, and the AASD had the OPA at 4 sub-users. So you're already, by doing that, limiting how fast you can upload information into the system, despite the fact that the Commission made it available to you to use as many sub-users as you like. The second point is that you can do all the different functions, the 4 functions, uploading candidate information, names and the supporting documents, uploading supporters' ID numbers, uploading supporters' signatures, and paying a deposit. You can do all of those simultaneously. As soon as you tick the checkbox of which election you want to compete in, you can then generate the payment reference and you can immediately start doing all those functions for that election. I'm going to get to some of the papers on that later, but one of the big mistakes that ACT and AASD made is not to realize that. And they wrongly thought that they had to complete certain functions before they could upload candidates. The third is that it permitted bulk uploading. And so it's important to be clear about what this is, because I think Mr. Ramaile confused it slightly. You didn't have to upload your candidates' names and ID numbers first manually and then in an Excel spreadsheet. It was either or. You could choose to do it one by one and fill in each candidate's name and ID number, push enter, fill in the next one. Or you could offline prepare a spreadsheet that had all your candidates or all your supporters in the spreadsheet, an Excel document, and then you simply upload that document with all your candidates for that election. So let's say you want 400 candidates to stand for the National Assembly. You put them in one Excel spreadsheet, upload it, all your candidates have been uploaded. The same for supporters. With supporters, the only difference is you could only have 1,000 supporters per spreadsheet. So for some of the elections, you would have to upload several spreadsheets. But that was the only limitation. And the important thing about bulk uploading is that the actual putting in of the information happens offline. And so whether the OCNS was working or not would make no difference to your ability to fill in that spreadsheet. The fourth element of the OCNS is that it provided feedback. So it would tell parties how well they were doing, how many signatures that had they uploaded, and track the progress. The fifth and final point to make is that it was not the only option. Parties could submit all their candidate information physically in Centurion, and particularly for the Labour Party and ACT, where that was half an hour to 45 minutes drive away from where they were. That was a real option. You could also provide your supporters' signatures physically. So it's important to distinguish between the supporter ID numbers and names. That had to be done online so that the Commission could check it in real time. But the signatures could be provided physically to the Commission. Now, Mr. Loxton is right that that's not permitted in the regulations. But an email was sent to all the parties on the 6th of March. It's PSM 21 to the Labour Party papers. And perhaps I can just read it. It starts with a list of all the parties that were sent to you. And then it says at paragraph 6, an unrepresented party or independent candidate must have captured the requisite signatures to contest the National Assembly or provincial legislature. You have to capture the ID numbers yourself on the OCNS. The ID numbers have to be on the OCNS. Submit the same lists that you've captured on the OCNS. So parties had lists where people would fill in their name and then they'd sign. So capture the same lists that have been captured on the submit the same lists that have been captured on the OCNS, either by uploading the documents onto the OCNS system or delivering the same by hand by no later than 5 o'clock on Friday to the Centurion office. So it's very clear that it's providing that additional opportunity for parties. So the question is, was the system, the design of the system, was it adequate? Could a reasonable party making use of the system have complied with the deadline? Yes, absolutely. It was not complicated or difficult to use. If used improperly, it was incredibly effective. So that's the one end of the evidence, what the Commission did positively. And then you can look at the results. What is the results of the system that the Commission designed? And there's three parts to that. The first is the success of other parties. So we know that there are 70 parties who will be on the ballots, who use the OCNS and will compete. That includes 56 unrepresented parties. 33 of them are competing in all three elections, in the sense that they're on at least one provincial ballot, one regional ballot, and the national compensatory ballot. 18 are only on one or more provincial ballots, and 5 of them are only on the national ballot. And the Commission gives examples of unrepresented parties who are able to use the system. Rise and Zansi, Action SA, the PA, who are all competing in all these elections. They all manage to comply. They all use the system. We give the example of the ELFSA, the Economic Liberated Forum of South Africa, which only got registered on the OPA, only registered an OPA on the 7th of March, the day before the deadline. It is competing in all three elections, national, compensatory, regional, and provincial, despite only starting on the 7th. The AIC was in a similar position. The AIC is a represented party, not an unrepresented party. But it also only started on the 7th and is competing in all these elections. And these parties use the same system, but they were able to comply. So the idea that reasonable political parties could not comply is simply inconsistent with these facts. That brings me to Mr. Loxton's big point that he started with. And it's really said that there is no more important fact than this one. But it's a damp squib. The claim is that 35% of unrepresented parties were unable to compete because of the OCNS. That's the claim. That the OCNS is the reason that they were unable to compete. But that is not the evidence. The evidence appears in paragraph 108.2 at page 35 of the Commission's answering affidavit in this court. Unfortunately, the papers are not paginated, but it's page 35 of the answering affidavit. So what the Commission says is 18 unrepresented political parties that sought to participate in the national elections did not meet the requirements to do so. That's all the Commission says. And it's all the Commission can say, because the Commission cannot know why these 18 political parties were unable to meet the requirements. It cannot know if that's because they were unable to gather sufficient signatures. They registered an OPA, but never gathered the right number of signatures. Or they never got around to nominating the candidates because of internal political party strife. Or they only started 5 minutes before. We don't know. The Commission cannot know why they did not comply. Mr. Loxton tries to twist this evidence into evidence that they didn't comply because of the failure of the OCNS, because he says that's the question his attorneys asked. But you've got to look at the answer that was given. And so this number, that 18 out of the 50, it's actually 56, 18 out of the 56 unrepresented parties were not able to comply, just doesn't tell the court anything. Because unless we know why they were unable to comply, the numbers mean nothing. What we do know is that of the 10 parties that have taken the Commission to court so far, the Electoral Court has found in the Commission's favor in each one of them. It's found that the reasons for non-compliance were not the failure of the system, but the negligence or tardiness of the political parties. That's what we do know. So with respect, the number really doesn't get anywhere. So the first important part of evidence is that reasonable political parties could comply. We know because they did. The second part of the evidence is the evidence of lockdown IT. And the evidence is that it was 100% uptime. And I want to read from paragraph 17 of the affidavit of Mr. Supnanan, which is attached to the Commission's answering affidavit in both the Labour Party and the ACT matters. And this is what he says. The website demonstrated exceptional stability, ensuring uninterrupted access for users. Such a high level of uptime is indicative of a well-maintained and resilient website infrastructure, capable of handling potential challenges and maintaining consistent online performance. That's the evidence of the Commission's service providers. And the evidence belies the claim that the system was constantly slow or glitched. I should deal briefly with the status of that evidence. It is evidence in the Labour Party matter. It's a direct access application. It's put up in the answering affidavit in the direct access application. So it is evidence. In the ACT matter, a different version of the report was put up in the electoral court without a confirmatory affidavit. When answering in this matter, because the Commission was putting it up in the Labour Party matter, we put it up in the ACT matter as well and asked for permission to introduce that further evidence on appeal. We submitted in the interest of justice for this court to admit that evidence. One, because it's directly relevant. It's not entirely new evidence. It's very similar evidence to what was put up in the electoral court. And it is in any event before this court in the Labour Party matter. So the last positive issue showing the results of the system the Commission designed is what happened in the last half hour. And this appears in PSM 23 to the answering affidavit in the Labour Party matter. So it shows what was uploaded to the website from 16:30 on the 8th of March. And there were hundreds of candidates, thousands of supporters, and dozens of bulk uploads, all in that last half an hour. So this is it's just not a system that stopped working. It's a system that was working for all these parties. So that's the Commission's version. Is it so far-fetched or clearly untenable that it can be rejected? No. The evidence is mutually reinforcing and corroborating. The Commission provided a user-friendly system, adequate training, and enough time to use it. And the majority of parties used it effectively. There's no party that the Commission knows of, other than those who've elected before this court, who can show that they were unable to comply because of the system. We don't know why those other 18 parties who haven't come to this court or the electoral court could not comply. And the stability of the system is confirmed by the service providers and by what happened in the last half an hour. So then we get to the applicant's version. Have they put up evidence to discount what the Commission has put up? And they really put up two types of evidence. So one is their subjective experience, and the second is arguments based on inference. So the subjective experience effectively goes, we are telling you that we experienced difficulties, and there are other parties that complained about the system, therefore the system didn't work. That's the logic of the argument. But the argument is wrong, because what the Commission had to do is create a system that enabled reasonable political parties to comply. And if we can see that the vast majority of political parties were able to comply, then the fact that some parties may have experienced glitches in the system is not evidence of unreasonableness by the Commission. It's not evidence that they failed to provide a system that a reasonable political party could use. Because in this type of case, whether there was a limitation of the right is an objective question, not a subjective one. It's not enough for a single party to come and say, I struggled to upload. They've got to show that the system would have made it impossible for a reasonable party to comply. The second is that the complaints may or may not be valid. There are other explanations for why any individual political parties may have experienced glitch or freezings or being locked out. It could be their internet connection, it could be something wrong with their computer, it could have been the way they were using the OCNS. The Commission can't be there sitting behind every user of the OCNS to figure out why you experience this particular glitch. It operates the back end. It sees the reports from its service provider, it sees what all the political parties are doing, and what it sees when it looks at that whole picture is a system that works. It's also interesting to note that these versions are inconsistent. The Labour Party says that the system didn't work on the 7th and 8th of March. ACT says it was only on the 8th of March. And they all accept it worked fine up until then. But that's not the way that internet systems work. It either worked for everybody, or if it didn't, then all parties would have experienced difficulties over that period. If only a few parties experienced difficulties, the problem is not with the system, it's with them. So when I describe these as subjective problems, I'm saying they go to the individual parties' experiences, not to whether the system worked or not. And that's the case that the applicants have to make. The second type of argument they make is not a case really based on evidence. It's a case based on inference. So they say, well, the Commission says it could have been done in one day. We were unable to do it in one day. Therefore, the system didn't work. That's the logic of the argument. But the logic doesn't follow. What the Commission says is the uploading could be done in one day if you had collated all the information and collected it in the proper spreadsheets and all you were doing is uploading it. That you could do in one day. But if you weren't able to do it, and other parties were able to do it, the inference is not that the system didn't work. The inference is probably that you didn't use the system properly. And particularly when one looks at the case of the ELFSA, that was an unrepresented political party that was able to comply in 2 days, the Commission's estimate is accurate. And if other parties were unable to do it in the same period of time because they didn't use it properly. So that brings us to what are the real reasons for non-compliance. I'm going to skip through these because I want to get to the particular cases. But essentially there's three. There's the applicant's delays. So the parties waited extensively long. The Labour Party delayed its registration and only started uploading candidates 36 minutes before the deadline. AASD is the best one. 1 second before the deadline, literally the second, 16:59:59. It first tries to upload a candidate. And ACT's only tried 2 hours before the deadline to try and upload its first candidate, even though it could have done so from the 23rd of February. The second reason for the non-compliance is really the difficulty of the signature requirement. It is onerous. It was difficult to collect those signatures. The Labour Party and the High Court explains its difficulties. But that's not a problem with the OCNS and the ability to upload information. That's a difficulty that will no doubt confront this court one day when the Rivonia Circle or some other party brings that case back to this court. But it's not relevant to whether the OCNS worked or not. And the third reason is that the parties made mistakes in the way that they used the system. They didn't register more users. They made the mistake of thinking they had to do things in sequence when they could have done it in parallel. They didn't make use of the bulk uploading, which would allow them to do a lot of the work offline. And they didn't submit physically when they could have, particularly the Labour Party and ACT. And so what's the conclusion? If one looks at the evidence of the Commission of how the system worked, and one looks at the paltry evidence put up by the applicants, and there's really no positive evidence to show that the system failed, other than to say, we experienced some difficulties with it. So when one looks at all of that, it is not far-fetched or clearly untenable that the OCNS worked. And even on the probabilities, it's more probable that the OCNS worked, and the reasons for non-compliance were the mistakes of the political parties. I'm now going to deal with each of the cases in turn, starting with the Labour Party. The first thing to deal with is the strikeout application. I don't want to spend too much time on it. There's two documents at stake. The Labour Party's reply and the supporting answering affidavits. The reply is pro non scripto because there's no application to admit it and it's not permitted under the rules. The supporting affidavits should be struck out because it's not permissible for respondents to put up answering affidavits that don't just say, that they go beyond just we support the relief of the Labour Party for exactly the same facts and that the Labour Party bases its application on. They put up new facts. Those facts are either just saying we also experienced difficulties without explaining them, or they're facts which do go into more detail but which the Commission has had no opportunity to answer. So they should be struck out for that reason. The second issue, question of the Labour Party is issue estoppel. The court knows the doctrine, and it clearly is it's the same issue that was before the Electoral Court that is now before this court. An important point to make, which I think Mr. Am made, is that in front of the Electoral Court, the Commission was clear that if the relief was granted, it would need to postpone, or need to request the President to postpone the elections. So postponement was already on the table before the Electoral Court. It was put on the table by the Commission. Mr. Loxton wasn't in the Electoral Court, but I was, and that was my submission to the Electoral Court, that it would have to request postponement, and that's what the affidavits in the Electoral Court say. So this idea that while postponement wasn't a possible remedy in an appeal is wrong, because there was a remedy put up by the Commission already in the Electoral Court. So there's no reason why the Labour Party couldn't have brought an appeal, and this court should not countenance this type of abusive process, because it is prejudicial to the Commission, because each time you put up a new set of facts, and you lose on the one set of facts, and then you come and hope that your new set of facts will do better. That's exactly what issue estoppel exists to prevent. So next on the Labour Party, it's important to note that the timing of what happened in the Labour Party case and how its case has changed. This case started in the High Court on the 6th of March, and its case in the High Court was not a case about difficulty in uploading documents. Its case in the High Court was a very different case. It said, this is at paragraph 19 of its answering affidavit in the High Court, which is annexure PSN 28 to the Commission's answering affidavit in this court. So, sorry, its founding affidavit in the High Court. And it says there are 3 obstacles. These are the obstacles it's experiencing. Why? And at that stage, it was asking the Commission to extend the deadline. It says there simply was not enough time to follow the prescribed process of securing the names, ID numbers, and signatures. It says more time is needed to canvass the electoral market. It says people were unwilling to sign because they were not registered. And it says the task of copying each person's name and ID number into Excel spreadsheets is simply unmanageable. And so on the 6th of March, it already knew it wasn't going to meet the deadline. And the reasons it knew it wasn't going to meet the deadline had nothing to do with the OCNS. It had to do with its difficulty of getting enough supporter signatures and putting those in Excel spreadsheets, not with uploading them onto the OCNS. But now it comes to this court and says, no, the only difficulty was the OCNS was slow on the 7th and 8th of March. That's inconsistent with its prior version. And if we look at what are the actual reasons why the Labour Party struggled, and I submit there are 5. The first is that it waited until 36 minutes before the deadline to upload candidates, even though it could have done so from the moment the OPA was registered. Its first problem really is its delay in registering as a political party. And then its delay, the Commission forms on the 7th of February it's registered, and it waits until the 29th of February to try and register on the OCNS so it can start using it. That's unexplained. In the High Court, the Labour Party accused the Commission of not informing it that it had been registered. And the Commission then put up the evidence to say, no, we did send you the email on the 7th of February telling you've been registered, and you delayed for 22 days. The second is it didn't take the advantage of the opportunity to submit physically. There's no explanation. The third is it created its own bottleneck by having only one OPA. The fourth is that it didn't give itself enough time to gather and collate the information. It says, and this is at paragraph 31 of its founding affidavit in this court, that when the deadline was reached, we had all the paper documents in boxes, and when the portal closed, we still had several boxes of paper documents that had not been uploaded. But if we're talking about upload, you had to take those paper documents and convert them either into scanned documents or into Excel spreadsheets. That was a time-consuming thing, which on their own version they hadn't done yet. Otherwise, it wouldn't be in paper, it would be on a hard drive. So those are the reasons why the Labour Party didn't comply. But then moving on to ACT, ACT did partially comply. ACT uploaded 50 candidates. It's on 8 of the ballots. It's on the national ballot, the Western Cape regional ballot, and 6 provincial ballots. But its version of what happened is revealing. It gained access to the OCNS on the 21st of February, but it only ever had its OPA and one sub-user. And it says that it uploaded all its supporters lists by the 6th of March, except for the Eastern Cape province. So it had done everything it needed to do by the 6th of March. But only then did it generate a payment reference so it could pay its deposit. It could have done that on the 21st of February. Instead, it waited until the 7th, or I think the payment is made on the 6th or 7th of March. But then it only stopped uploading candidates on the 8th of March, 2 hours before the deadline. Again, there's no explanation for this other than it didn't understand the system. It thought it had to pay the deposit before it could upload candidates, but it's wrong. It could have uploaded candidates from the 21st of February. And the first complaint it makes, the first time it calls the Commission and says, ooh, the OCNS isn't working, is at 2 o'clock on the 8th of March. Before that, it was working swimmingly. So it had on its own version from the 21st of February until about 1 o'clock on the 8th of March, where the OCNS was working. Mr. Am said that this question, that ACT's understanding that it had to wait to upload candidates until it had paid the deposit is not disputed, but it's fundamentally disputed. And he referred to page 205 of the ACT record, which is it's this workflow document. It's very difficult to read in this version. There's a much better version, which is PSM 17 in the Labour Party case, which shows the workflow. But if you look at that workflow, what it shows is exactly what I've said, which is that you register the OPA, you generate the payment reference, which happens when you tick the box, and then you can make the payment, or you can upload candidates. You'll see there's this little dotted line over here that goes underneath. This is payment, this is the dotted line to say go straight to candidates. So you can do them both once you've selected the election you want to compete in. But it's even clearer at page 219 of the record, in the user manual, where it says the party will only be able to capture candidates for regions, provinces, where they've generated a payment reference number. Not paid the deposit, not uploaded signatures, generated the reference number, which happens once you select the election. And again, ACT didn't take advantage of physical submission, and it didn't take advantage of bulk uploading. It wasted time. It says it uploaded 120,000 supporters. It only needed to upload 47,000 supporters to compete in all the elections. And if it had done it in bulk, it would have taken it a matter of, once it had collated the information, the uploading would not have taken long. Instead, it spent weeks doing it one by one, 120,000 supporters. It worked hard, but it didn't work smart. So those are the real reasons ACT doesn't have as many candidates on the ballots that it wants to have on the ballots. There's another point we take about the way that ACT has structured its case, and it really is very strange if you look at their notice of motion, exactly what is the decision they're reviewing. It seems that what they want to review is a decision, or a failure by the Commission to take a decision whether to amend the timetable after they failed to comply. And the Commission's position on this is simple. It has the power under Section 22 sub A to amend the timetable. And that power is triggered when it is necessary to ensure a free and fair election. And it will exercise that power when the trigger exists. But it will not be forced into taking a decision every time a party asks it to take a decision. Because otherwise it would be unduly burdensome. Every time a party or anybody said to the Commission, we want you to amend the timetable, the Commission would have to convene and would have to take a decision on it. And it says, we will do it when it's necessary. And if it's not necessary, we don't have to take that decision. But so we submit that they've gone about it the wrong way. But ultimately it doesn't matter, because if the OCNS worked, then an amendment was not necessary for a free and fair election. If the OCNS didn't work, then an amendment probably was necessary for a free and fair election. So it really boils down to the same question. It's just a very strangely structured case. That brings me to the AASD. There's a couple of problems with the relief that the AASD seeks. The first is that it's not competent. What they seek is individual exemption. If one looks at what they ask for, they say they want an interdict against the Commission to restore access to the system so they can upload their outstanding candidates. But we know from IFP, so the IFP case at paragraph 57, this court does not have the power to grant relief that amounts to allowing the IFP's participation in the election when it has not fulfilled the requirements of the Act. So that type of relief is just not competent. And that's because there was no compliance. Mr. Ramaile tried to make this case of, well, we've done everything except push submit, and that's why there's substantial compliance. That is not their case. If one looks at the founding affidavit in the Electoral Court, paragraph 15, it's not in the record that I have for this case. I'm not sure if it's in the court's record, but the other documents are there, but the founding affidavit isn't. But this is what it says. On Friday, 8 March, the applicant was in the process to capture and upload the AASD list of candidates when the system locked them out at 1700. At that juncture, only one candidate capture template had been successfully submitted when the system lockout occurred. That's their version. Not that all their candidates were waiting in the lobby just for them to push submit. That's never been their case. If that had been their case, the Commission would have given a different answer. I know what that answer is. I don't want to give evidence from the bar, but it would have been a very, very different answer if that had been the case. It's also confirmed the next day they write a letter to the Commission where they say, we were in the process of capturing and uploading candidates when the system locks us out. But that's not what Mr. Ramahile told me. He said, no, we've got them all, they were uploaded them in the cloud. We just had to push submit. Not their version, and that's not consistent with the evidence that the Commission put up. As far as Section 28 goes, as Justice Majid pointed out, that only applies once you've got in a candidate list. If you fail to provide the nomination form, the signed nomination forms, and the signed declarations to comply with the code, all those documents, you can fix that afterwards, and the Commission has an obligation to notify you. But if the Commission doesn't get a candidate list, then Section 28 never kicks in. On the question of whether the Commission took a decision, the Commission's position is that it doesn't take a decision. And this was recently confirmed by the Electoral Court in the Arise Africa matter, where it says the exclusion happens by operation of law. So at the moment of the deadline, you're either compliant or you're not. The Commission isn't taking decisions. It's like the Paniti case, which I'm sure the court is aware of, where a person would lose their employment if they were absent without leave for 30 days. No, the administrator doesn't take a decision, you just lose your employment. It's the same here. You're either in or you're not. The Commission doesn't take a decision. But again, that's a technical dispute that doesn't particularly matter. If we go to why did AASD not comply, the reasons are the same. It waited until a second before the deadline. Why did it wait? Because it misunderstood the system. And when one looks at the founding affidavit in the Electoral Court, what are the reasons it gives? It complains about load shedding. It complains that the Commission changed the time from 9 in previous elections to 5 in this election. And it complains that the OCNS only allowed them to be on for 20 minutes. That particular complaint, the 20 minutes complaint, is disputed by the Commission. No other party raises that. And what the Commission says is if you don't do anything on the system for 20 minutes, it may log you off. If you're inactive for 20 minutes, then it will log you off. That's common in many systems. I'm sure the justices have used their bank. If you don't use the bank, it'll log you off for security reasons to make sure that other people can't take advantage of it. So that's what's happening there. And the excuses of load shedding and changing the time are not excuses. They're just, well, they're not reasons that a reasonable party can rely on to explain why they didn't comply with the deadline. So against all of that, what do we have? We have reasons why for each of these parties we can see the mistakes they made. They tried, but they didn't take advantage of those things. They left things too late. They didn't give themselves enough time to collect all the information. And that's why they didn't comply. Not because the system wasn't operating. That leaves me with just two submissions, jurisdiction and remedy. I'm going to say very little about jurisdiction and focus on remedy. We've made the submissions in the heads that this court does not have jurisdiction to resolve cases that are solely disputes of fact. It may be different in direct access cases, but in appeals, particularly appeals from the Electoral Court, where there's no issue of law raised, where it really is just a dispute of fact, this court should ordinarily not exercise its jurisdiction. Whether that's strictly because it doesn't have jurisdiction, because it's not a constitutional matter or an arguable point of law of general public importance, in some cases it will be that. In some cases it may be that the court has jurisdiction, but it should refuse leave to appeal because it shouldn't be hearing those types of cases. The apex court should be resolving legal issues that affect the country as a whole, not resolving disputes of fact already determined in the Electoral Court. That brings me to the remedy. So we submit that there's three important principles for the court to keep in mind. So obviously, if wrong, we submit the correct remedy is to dismiss the applications, but the court is not with us. The first is that there cannot be exemption for particular political parties. The Commission has a firm view about this, that if the problem was a system, and that's the allegation here, that the problem was with the OCNS system, that affected all the parties. It affected even parties who, like ACT, are partially compliant. They're on some of the ballots, but not on all the ballots they would like to be on. So it's not just the 18 who are not on any ballots. There may well be other parties who say, well, we managed to get on 5, but we would have liked to be on 7. And if the system stopped them from doing it, they should all be given the opportunity, a reasonable opportunity to nominate the candidates they wish to nominate. So that's the first principle. The second is that if parties were excluded from competing, so if on the OMSA test, the Commission didn't design a system that allowed reasonable political parties to compete, that would ordinarily render the election not free and fair. And that brings me to the third principle, which means there would have to be an amendment of the timetable. an amendment to the timetable will result in a postponement. And the reason is what's happened since. Because if the opportunity for candidate nominations is reopened, then the Commission goes back to where it was on even before the 8th of March. And there'll have to be a certain number of days for parties to submit further nominations. And then the Commission will have to go through the Section 28, 29, 30, and 31 process, which normally takes a month. Could probably be condensed, but still, it's a process. You've got to check all the candidates. You've got to put the lists out for objections. You've got to decide the objections. It takes at least weeks to do. There's got to be appeals. There's got to be electoral court. Those appeals might end up in this court. There's one is on Friday, and that takes time. And the Commission, only once that process is finished, can it print the ballots. It's already printing ballots. If it has to go through that process, it will have to start again, and the ballots will not be ready. Because the ballots for the national election have to be ready on the 17th of May, which is just 11 days away for the overseas voting. And so the Commission says it cannot do it. It does not have a solution like the IFP stickers in 1994. And I think part of the reason for that is that the electoral framework now is much stricter. 1994 was in some ways a rough and ready election. Now we have strict electoral requirements that we have to follow in terms of the Electoral Act, that unless the Commission suspends unless the court suspends the operation of that legislation, the Commission must follow. And so it doesn't see a way that it can permit all the parties an opportunity to nominate candidates and be ready. And so that leaves the court with a choice to require the Commission to amend the timetable to reopen the window, which will lead to a postponement, or to provide another remedy that will not as effectively vindicate the rights of the applicants. And the one proposed in the heads of argument is a declaration that their rights have been limited. And I accept that that is a poor second prize for these applicants. Because it doesn't get them into this election. But this court has to grapple with what is just and equitable, and what are the costs of postponement. And the costs of postponement are more than R500 million in costs. Just briefly on the registration, the Commission has to have a new registration weekend to ensure that voters are registered in the correct province before the election, so it can't have so long before the last voter registration weekend for the next one. And it will be disruptive for political parties. The Commission has provided that evidence, but it's also common sense. Political parties have been campaigning and planning for an election on the 29th of May. They've spent their money on TV adverts and posters with that in mind. That money is now spent. If the election is postponed, they will be negatively affected. We don't need evidence from them to know that. And so the court will have to choose between fully vindicating the right of the applicants against the immense disruption that postponement will cause.
It appeared that you actually reached the end of your submissions when the bell went.
I was following the clock very closely, Deputy Chief Justice.
Okay. Mr. Bishop, ACT objects to the admission of lockdown's confirmatory affidavit, and is it annexed to appear someone to the Commission's answering affidavit?
Yes.
Which complains introducing evidence on appeal.
Yes, that's correct.
Now, I want to find out from you if the Commission should not have filed a substantive application.
I believe we did, Deputy Chief Justice. There is a notice of motion, and the justification is given in the answering affidavit. There isn't a separate affidavit for the application of introducing evidence, but there is a notice of motion, and the justification is in the answering affidavit.
All right, I missed that document.
I know that one was prepared. I hope it was filed. I'll double check.
Two of my colleagues confirmed that they have actually cited it, but perhaps you can help me because I don't have it now. What is the justification? Why was this evidence not led in the electoral court?
Yes, so a report from Lockdown IP was put up in the electoral court. I think it's important to note that the electoral court operates on extremely tight timelines. So I believe in this case, I think in ACT we had 2 or 3 days in order to put together an answering affidavit. And the lockdown report that was put up there was the one that was put up. Subsequently, particularly when we've got the Labour Party affidavit, we consulted again with Postpone because this was a fresh application that required a fresh answer. And we got a additional report and a confirmatory affidavit in the Labour Party matter, which has been put up, and we can put it up because it's a first answering affidavit. We took the view that given we put up a version of it in the electoral court in the ACT matter, and we were putting up a different version in the Labour Party matter, and the cases would be heard together, it was fair for us to also seek to put it up in the ACT matter, so that they would have that side would have an opportunity to deal with it. It's not substantially different from what is in the electoral court, but it's a more complete version, more substantive version of the same basic evidence.
The service provider claims that the system was 100% functional throughout the material period. But in various parts of the Commission's answering affidavit, it is not disputed that there may have been glitches, the system may have been slow, froze, hung, whatever that means. Now, I want to know what one is to make of this seemingly contradictory evidence. What does 100% functional mean?
Yes. In the affidavit, what the 100% uptime means in the affidavit of Mr. Sukunan. So he explains what it means, because I said put into about what does 100% uptime mean. And the explanation is that the website demonstrated exceptional stability and showed uninterrupted access for users. Such a high level of uptime is indicative of a well-maintained and resilient website infrastructure capable of handling potential challenges and maintaining consistent online performance. So that doesn't mean that there may not have been, the Commission cannot responsibly say to this court that these political parties are all lying and none of them ever experienced any glitch or any one-off or anything like that. We can't say that, we don't know that. What we know is that there may be other reasons for that that are not related to the system, that may be related to their internet connection or the computer that they're using. Or there may be small gremlins that happen in the system occasionally. We can't say for certainty that didn't happen. What we know is what our service provider tells us, that generally it was capable of handling potential challenges and maintaining consistent online performance. So I don't think those two are necessarily contradictory. I think you've got to read that overall it was working well. There may have been some small problems. Some of those were probably had nothing to do with the system and were caused by the particular political party's connection. Some of them may have been small glitches in the system, but they weren't so big that they prevented feasible parties from complying. Again, the standard is not perfection, it's reasonableness.
All right. Last question. You have made a proposal that if we find in the applicant's favor, we grant a declaratory order which you yourself have considered is exceedingly poor second prize.
Yes.
Now, I want to ask if there is any other appropriate remedy at all that you could grant that would mean something to them, short of amending the timetable and the unthinkable of postponing the election.
The difficulty, Deputy Chief Justice, is the only thing that would really satisfy them is something that would allow them to compete in the election. And unfortunately, because of the delay, and the delay is not their fault, the delay is a result of the litigation process, but it is what it is. And today, there is no other remedy the Commission can provide for these applicants.
And cost, either way?
Yes, Deputy Chief Justice, if the applicants, if the applications are dismissed, the Commission, it has said in its affidavit that it asks for costs. It seems to me that Biowatch would apply in these cases unless the court concludes that the applications were frivolous or vexatious. I leave it in the court's hands. If the applications are successful, there's conflicting dicta. There's some, like in Kloppe, this court ordered costs against the Electoral Commission, but there are other cases such as in Electoral Commission versus Democratic Alliance in the SCA, where the SCA held it was inappropriate to order costs against the Electoral Commission when it was performing its regulatory role. We would submit that the same is true here. The Commission has acted responsibly as the regulator, and that if it is unsuccessful, there should be no redress of cost against it for those reasons.
All right. Thank you.
Mr. Bishop, mine is just housekeeping for myself.
Yes.
This point that Mr. Loxton laid much emphasis on of the 35%, I couldn't keep pace with you with the submissions you made as to where that particular passage of the evidence is to be found. So my note is incomplete, so I really just want to complete that note. You say that that 35%, and I think I did pick it up somewhere, probably in your submissions, that you say it doesn't mean that that 35% did not comply because of OCNS
Yes.
malfunctioning. Can you just make that submission again for me, please? I just want to make a note.
Yes.
And also where it is in the papers where
Yes.
you answered it.
So to make the sequence is important, that the Labour Party's attorneys wrote to the Commission asking for various pieces of information, including how many unrepresented parties were unable to compete because of the OCNS. The answer is given in the Commission's answering affidavit, paragraph 108.2.
Sorry, 1842.
108.2.
Yes, okay, I've got it.
It's page 35 of that affidavit, where the Commission makes clear that 18 unrepresented political parties that sought to participate in the national elections did not meet the requirements to do so. But the Commission doesn't say, because it doesn't know, why they were unable to do so. It knows that they registered an OPA, and so they obviously indicated an intention to compete, but that they didn't meet the requirements by the deadline. But whether they didn't upload sufficient signatures or candidates because they had difficulties with the system or because they didn't have sufficient signatures or candidates, the Commission cannot know unless the parties tell it. So it's not really very helpful information in assessing how effective the OCNS was. It doesn't tell the court very much.
And, I mean, these are voluminous papers which we've had to read constantly over the last week as they streamed in. But is there any way in the papers, can you help me, is there any way in the papers that gives statistics of how many represented parties were able to register, were able to comply with the deadline?
So I think the best reference is that there are 14 represented parties. So ultimately, these numbers, I think, changed a bit. In the electoral court, you'll see the number of 87. And ultimately, the number, can you just find me that reference for 70? It's 70 political parties that are on one or more ballots, 56 unrepresented and 14 represented.
Thank you. Thank you.
Yes. So, sorry, one second, just get the reference for that. So in the ACT papers, in the Commission's answering affidavit, page 20, paragraph 68.
Thank you, Mr. Bishop.
Mr. Bishop, it's late in the day.
Yes.
You've been on your feet for an hour. Let's see whether we can cut to the chase. The easier or the neater way of dealing with this case, correct me if I'm wrong, or clarify, if we find that there was a dispute of fact, which the parties could not approach us, we could dismiss it on that basis, and we would find also that the Electoral Court applied the principles in plus connivance correctly. And that would put paid to the application by the ACT and the AASD.
Yes. And I think that the court could just say it's not in the interest of justice to grant leave to appeal because it's purely a dispute of fact without necessarily having to delve into the intricacies of jurisdiction.
Okay. And as far as the Labour Party is concerned, we would have to say that approaching this court by way of direct access, it misconceived the position.
Yes, and that it's refusing, it's not in the interest of justice for direct access for issue estoppel, because it was possible for it to bring the appeal and still seek the relief that it's seeking. Yes. That is definitely the quickest
That's
way.
a cleaner way of dealing with this.
Yes, Justice Mator.
Thank you.
Mr. Bishop, thanks very much for your submissions. I want to ask you a number of questions. The first relates to your claim that this court doesn't have jurisdiction over factual disputes. My understanding is that when rights or constitutional issues are violated, there will often be factual situations which require us to determine if there is an infringement of a right and whether that infringement is permissible. There are a number of cases. SAFU, for example, says it wasn't a rights case per se. In the event, there can be no doubt that this court is obliged to determine factual issues where they relate to constitutional issues. You cited ANC versus IEC, which actually involved factual disputes around the ID numbers of a Mr. Maluleke, and the court adjudicated that dispute. So I wanted to put those examples to you. Evictions cases come to mind as well, where they're very factually implicated. And given that we have a claim that's made on the basis of rights, on what basis then can we dismiss on the interests of justice do not allow us to consider a factual dispute of this kind?
Yes, thank you, Justice Vilches. I wouldn't say that this court cannot consider factual disputes, that they will arise. The question is whether, when a case, there's no legal dispute in the case, there's only a dispute of fact. Even if it concerns a constitutional issue, whether in those circumstances, I think there's two levels. One, whether the court has jurisdiction, and two, if it has jurisdiction, whether it's ordinarily in the interest of justice to grant leave to appeal, where it's only a dispute of fact. And what this court has said is it is an apex court, and the normal relief for where lower courts get things wrong on the facts, even in constitutional matters, is an appeal to the next higher court, not to this court. This court exists as an apex court to set the law, not to get each case right. And so for that reason, it either isn't in the interest of justice or it doesn't have jurisdiction. The additional level is particularly with electoral matters. The Section 96(1) of the Electoral Act says that the Electoral Court, that there's no appeal or review against any decision of the Electoral Court. And this court in ANC says, well, yes, there's no appeal or review unless it's a constitutional matter. But that decision only makes sense if you identify a category of electoral cases against which there is no appeal or review. And it seems to me that the one way to do that is to say, well, where there are purely factual disputes that have been resolved by the Electoral Court that do not raise any issue of law, that would be a category to which 96(1) can still apply. But I accept that the general proposition that it stated that highly that this court can never resolve disputes of fact, that's not correct.
Okay, thank you. The second point I want to raise with you is, like, the impression on the papers to me is that on the IEC's own admission, there was a number of complaints about the OCNS system, about hanging. And the IEC essentially then says, well, we're not considering amending the timetable. These are complaints, it's your fault, and doesn't actually respond, in some senses, to the complaints before it. Section 1951E of the Constitution directly recognizes that people's needs should be responded to by organs of state. And so my question to you, and that's my trouble in this case, does not an organ of state like the IEC have a duty to be responsive to the problems that are drawn to its attention? And if I have a look, we sort of quantified these. 12 parties, I know we may or may not admit these, said the portal malfunctioned. 7, the portal's payment function was not working. 9, that bulk uploading difficulties in the portal, including uploading of signatures. At what point does an organ of state actually say, well, there is some problem here with the system, and we're going to try and act in a way to enable people to stand in the election and amend the timetable if it may have been by a week, for instance?
I think, Justice Vilches, there's different forms of responsiveness there. The one is responsive to the complaint. So somebody sends an email or phones and says, I'm having difficulty with this. And the evidence is that if one looks at the Labour Party and the ACT cases in particular, that the Commission did respond. And in many cases, it provided a useful response. Sometimes it didn't. In the electoral court, I can't remember exactly what the details were, but there was a question about why didn't the commission just tell this party that this was the way to do it. But the commission only knows the problems that the parties bring to its attention. And so I think the evidence does show that it was responsive in that sense. Of course, the commission has limitations. It doesn't have an unlimited number of staff. This is a busy time. It may not have answered every complaint immediately, but I think really the commission's officials tried very hard to be responsive. So that's the one of responsive to complaints. And there may be a complaint that this isn't working, and that may be because you're not using it properly. That was the case of the one example I gave of the Labour Party, where they were using the wrong tab. And those could hopefully be solved. Or it may be a problem with that particular party's internet connection, which the commission can't solve. Or it may be a problem with the system. But the fact that the complaints exist at a time when many political parties would have been using the system doesn't tell us that it's the system that was malfunctioning, when you have all the other evidence showing that it was still working. With regard to the second question of whether it was the commission, in order to be responsive, should have amended the timetable, the commission could only amend the timetable if it was necessary for a free and fair election. That's a statutory precondition. And so it had to be satisfied that the amendment was necessary. And if, based on the evidence it had before it, it said, but we've given people enough time, we've given them enough training, we've given them a system that if they use it properly, they'll be able to comply. And that as soon as we start changing deadlines, maybe they could have changed by a few days without impeding the rest of the performance, but every change has knock-on consequences for the rest of the election timetable, which means everything else has to be done faster, which creates additional risks down the road, that you only amend when it really is necessary. And so I'm not sure it shows non-responsiveness that the commission didn't amend.
And that's one of my worries. I mean, this court is held in different circumstances, I accept. Like in Mazibuko, for instance, the Constitutional Court recognized that flexibility is an essential part of reasonableness in some senses, and I understand that the same standard doesn't necessarily apply over here. But it seems like the election timetable was set, and almost nothing could deter the IEC from actually keeping to that timetable without, even with many, many complaints. It didn't seem to be prepared to be flexible in any way, and I'm worried about enshrining that inflexibility into our law.
I think in this context, Justice Pilchard, that rigidity performs an important constitutional function, that it provides certainty to political parties, and this is what the case law says in the Liberal Party IFP, and if one looks at, I think it's a good party case in the electoral court, where it says that the importance of adherence to timetables is also to allow the commission to perform its function. And again, there's a statutory precondition. And so it's not enough for the commission to say, well, we'd like to help you out, and so we can. It doesn't have the statutory power to amend the timetable unless it reaches a conclusion that it is necessary for a free and fair election. And so that comes back to the fundamental question, which is if the commission had provided a system that, on the probability that a reasonable party could use to compete, then it's not necessary to amend the timetable. And there are risks of doing so to free and fair elections. And so there's a degree of balance in there. It's not just a question of one way. More flexibility is always good.
And the last set of discussion that I wanted to have with you was around, and thank you for addressing my concerns around Plascon evidence in this context. I am worried that in context of election disputes, what Plascon evidence essentially does to any party coming before an electoral court or before this court is essentially say, well, we don't have action proceedings available. We generally have to come on motion proceedings. Therefore, the IEC's version is almost inevitably going to be preferred. And so what you do is essentially you load the dice against parties seeking to enforce either their right to vote or their right to stand for an election. And so I'm very concerned that the way in which we utilize laws, an evidentiary rule in this context, is going to actually inhibit the ability of individuals to actually give effect to claims to address possible infringements of their right.
I think I'd have a few responses to that, Justice Pilchard. The first is, the commission is often an applicant in the electoral court, so it's not always the commission that has the benefit of Platscon evidence. I've brought multiple cases for the commission in the electoral court where the commission has the burden of Platscon evidence. So it depends on the case. The second response is Platscon evidence is not. In order to get the benefit of Platscon evidence, you can't just deny. You have to put up a positive version. You have to put up a version to show why you say the applicant is wrong. If you just say I deny it, then often, even on the application of Platscon evidence, the court will accept the applicant's facts. And I'm not sure why election disputes should be different from other constitutional disputes, which are resolved on Platscon evidence. I accept that because of the urgency of elections, it's often very, very difficult or even impossible to have oral evidence. And although that, again, that isn't always the case. Sometimes electoral matters are not urgent, but it is normally the case. But there's also a risk of doing it the other way, because then you put the commission in a very difficult position, and you put the court in a very difficult position of analysing probabilities merely on affidavit, which is exactly what Platscon evidence is designed to avoid. And also, I made a submission earlier, but I would be hesitant about changing the law in this case, where the issue hasn't been fully argued or debated by the parties.
Yeah, well, I doubt Platscon evidence will be, in general, the issue will arise in the course of other proceedings. In general, it will be unusual to have a full frontal challenge to the rule itself, and I imagine it would develop according to various particular cases where it's shown to be inadequate. And I suppose you put forward the reason in this case would be urgency and the particular nature of the fact that there's no alternative. My sense of the underpinnings of the rule is that an applicant could have gone on action proceedings in other cases, and therefore, if you decide not to, the respondent's version is preferred. But in these cases, that isn't a possibility, and so therefore there's a question of whether the conditions for the application of the rule are actually here.
Yes, I accept it is different. I mean, there is a similarity in review proceedings, which I think Mr. Am referred to, which do also have to be ordinarily brought on motion. You have to have a special application to go to action proceedings. That the difference is you get the record, but that doesn't necessarily change the question of how the disputes of fact are resolved.
Thank you, Mr. Bishop.
Shall we take a short comfort break, just for 10 minutes, until go request?
As the court pleases. The Commission's insistence on compliance with the rules cannot be viewed as irrational. The portal has been open since 23 of February 2024 to enable political parties to upload all the required information. I'm of the view that Operation Dudula has itself to blame. It left everything to the 11th hour. I'm mindful about Operation Dudula's asserted political rights enshrined in Section 19 of the Bill of Rights. However, rights go hand in hand with responsibilities. Operation Dudula has a responsibility to ensure that it complied with the set rules to enable it to contest the National Assembly elections. And we submit the same principle should apply in this matter. Thank you, Deputy Chief Justice.
Any reply, gentlemen? Mr. Loxton?
Thank you. Very briefly. First of all, as regards the insistence by the Commission that they should apply the law strictly and that is what ensures free and fair elections and that they shouldn't change things ad hoc, they're not really consistent. They changed the law, well, they ignored the law relating to the physical or the online uploading of signatures for supporters. And recently, I see there's a notice given by the Commission that they extended the timeline for the application for special votes on the 3rd of May from 5 p.m. to 12 p.m. to midnight. So they're not exactly consistent in that way. It's important that we get the 65-35% issue right. The learned friend has said it's not that they haven't said that the 35 could not comply with requirements because they could not upload information to the portal. But in fact, that was the question that they answered. If you look at their letter, you will see that they say they're going to answer the question. And when you look at the answering affidavit at paragraph 108, you'll see they say they have answered that question. In other words, we must interpret the answer as being an answer that 35% of those that attempted to upload the relevant information failed to do so by the timeline. Now, one of the important questions here is what is fit for purpose? Because the learned friend has phrased the question. He says, you've got to look at the probable consequences of being unable to exercise the right, even if one acts reasonably. If the probable consequences are that you will be excluded from participation in the election, then there's a breach of Section 19 that flows from that. So the question is, how do you apply the test in this particular case? If the Commission had said they had designed a system, electronic system, for uploading information, and they are happy and proud to announce that when it operates, they estimate that at least 65% of people will be successful, there would have been outrage. There would have been an outcry. So what is the answer to those percentages? They say, well, a couple of things. They say, first of all, your objections of the Labour Party's objection and other parties' objections is personal. It's not objective. That's not true. Everything is objective. If I'm driving a car and the brakes fail, and I observe that the brakes fail, that's an objective observation. It just happens to apply to me. So from that, you get to a situation where you say, what do we have on either side of the equation? And if you apply Plascon-Evans, if it is applicable, what's the result? On the one hand, the Commission says, look at my service provider, and you say, yes, all right, but it's unlikely that that's correct because you yourself admit to complaints which are genuine, they're not dishonest, of the system hanging, of being kicked out and the rest. So you can't take that at face value. Secondly, they say, well, look at what other people have managed to do. But that's an irrational approach. If A manages to comply and B doesn't, you can't say that it's the system or it's A or it's B. But if 35% do not manage to comply, then unless you're dealing with a cohort which is particularly backward, then it's only explicable by the fact that the system is not working as it should for the people for whom it was designed. And the impression that one gets when one listens to what my learned friend has had to say is that the IEC has constructed a survival course. And on that survival course, there are many obstacles. Some will survive, some will overcome the obstacles, some will not. 65% will actually get to the end of this course. 35% will not. Is that satisfactory? Is that what this court will finally say, knowing those statistics, knowing those facts, we find that there's been no deprivation of the right to vote, the right to put up a candidate. That's okay. The IEC, the Commission, has done its job. No one should feel done down. No one should complain. And we say that that can't be right. And it can't be right to deny access to this court by saying, well, you've applied for direct access, but actually you should have appealed. And if you had appealed, we would have said to you, but we're stuck with the facts that were found, that the electoral court found, and that were before it and its findings, so you're going to fail on appeal. So if you come direct access, you fail because it's direct. If you come by appeal, you fail because of the facts before the electoral court. So what you're really saying to these parties is there is no road ahead for you. Sorry, you didn't make it. You didn't complete the course. Go home. Try another day. That's not a satisfactory outcome. And we say that even if you apply the Plaskon-Evans rule, because the Commission is unable to say to any of these parties, the Labour Party included, you did not experience the problems that you did, it cannot rely on Plaskon-Evans to say to this court, accept our version. Unfortunately, there are a great number of people who couldn't comply, but it is the survival of the fittest. Let the fittest continue. Those who are not fit enough, too bad. That's not a right outcome. Thank you.
Thank you, Mr. Loxton. Mr. M? Sorry. Any question? It's been a long day, sorry everyone. Any questions, colleagues, for Mr. Loxton?
Sorry.
I'm sorry. And you're so quick to sit down.
On the short reply. It's home time.
No questions for you, luckily.
Thank you.
What he says is, Plaskon-Evans applies, and you must decide on what we say. But at the same time, the rules of evidence are thrown out the window because what we'll do is we'll file substantive affidavits on appeal to make out the case, to render what was inadmissible before the electoral court and to try and render it admissible before this court. What's good for the goose has got to be good for the gander. It can't operate both ways. But we submit the difficulty that my client faces is that it's now placed in a position where this court, with respect, over and above the Sophie's choice you've got to make about if we are to succeed, about what's to happen. But my client's case gets contaminated with evidence that is relevant in another appeal, being the report of the IT experts. That evidence, and my learned friend hasn't for a moment suggested that it was admissible in the electoral court. And this all turns on whether there is a genuine dispute of fact. Because at its high point, the case made for the Commission in on the dispute of fact is, well, we've got these expert reports. Well, they're inadmissible and they're irrelevant. And they weren't before the electoral court. And 65% or whatever number managed to do it. So from that, we draw an inference. But we set out in our heads the circumstances when it's appropriate to draw an inference. An inference can only be drawn when it's sustained by the proven facts. And the Commission puts up no admissible evidence to justify the drawing of that inference. And in any event, as my learned colleagues point out to me, Section 19 is a subjective right. It's a right that is available to every individual, and not most people, not 65% or 35%. So we submit in this application, there is no admissible evidence. There is no appropriate inference to be drawn that justifies the existence of a genuine dispute of fact. Now, my learned friend says rules must be enforced. We agree rules must be enforced. He says deadlines matter. We agree deadlines matter. But so does the system you create, which you seek to rely on for the enforcement of the rules and for the enforcement of the deadlines. I don't know if the Commission's sensitive about its system, because it definitely adopts that attitude in its papers. This is not a blame game. It's not about whether or not the system was designed with the best intentions, because he focuses on design and not so much on functionality in his arguments. It's about whether the system failed or not. And the system may have failed for various reasons, completely unrelated to the Commission. But the objective fact is that the system failed. So it's not about who's to blame. It's not about who's responsible for the system. And that objective fact creates the objective impossibility for my clients to have complied. My learned friend made an incorrect submission, and it's part of the problem when you roll all of these cases together, because the facts in one case contaminate the facts in another case. He says that our client, my client, only complains about the system on the 7th or the 8th. That's not correct. If I can ask you to have regard to the founding affidavit in the application before the Electoral Court, page 17, paragraph 20.5. And I'm going to read this also within the context, if you can maybe put a mental flag there, as to what a reasonable party would do, because that's my learned friend's argument. What would a reasonable party do? The founding affidavit, 20.15. On 20 February 2024, ACT sought and attempted access to the IEC online portal, but it was only able to do so on 21 February 2024. And we, my team and I, commenced the onerous task of first uploading ACT supporters list. This process was frustrated and delayed because of the defects and non-functionality of the IEC online portal. Despite these challenges, and as far as I can recall, ACT concluded the submission of its supporters list on 8 March 2024 in respect of the Eastern Cape. It had submitted its supporter list for the other 5 provinces and nationally by the 6th of March 2024. So, it's not true that it's suddenly convenient, because I submit that that's the inference my learned friend would want to be drawn, that it's convenient that we only complain on the 8th when it really matters. That's not the case. We always complain, but we did what we could. Now, he beats a drum about what a reasonable political party would do. I want to ask you, because we deal with it in our heads of argument, we set out a list, and it's again going back to those common cause facts about what my client did in order to be able to submit its lists timeously before the deadline. And that is at page 8 of our heads of argument. We started on the 21st. We secured a venue in the middle of Sandton, a venue that had stable internet access and high speed. We hand-selected 20 individuals who were suitably skilled. All of them had their own individual laptops. All the laptops were new and recently purchased. There was a 20-person team that was managed by 4 individuals who used the access code. So there were 4 users. Working hours in most days ran from 13 to 15 hours, starting at 9 o'clock and often ending past midnight. Now, isn't that what a reasonable party would do in order to meet the deadline? It's not submitted, Marlene, if it doesn't submit that my client was unreasonable. It just said it left it too late. But that's with respect like looking at a mountain through a straw. All you see is what you see through the straw. If you take away the straw and you look at the entire mountain, you will see that from the 21st, my client acted reasonably. And it cannot be said that my client left it to the last minute, because the Commission's case is that it would only take an hour or 2. And my client had that hour or 2 and it couldn't submit. So, turning then very quickly to Plascon Evans. There is no dispute. You can't be free and easy with the laws of evidence in this court on an appeal simply because the evidence is relevant to another matter. It's not admissible here. And then dealing with the relief. This court, if the court is inclined to agree that the system failed and that the failure of that system resulted in my client's inability to complete its list, then there's obviously a Sophie's choice. But with respect, you can't allow the election to continue when you know in your hearts of hearts it's not free and fair. Because there are 121,000 supporters of my client's political party who are now precluded from voting for reasons entirely beyond their control. There are 470 candidates from my client's political party who deserve to be on the ballot and are not going to be there for reasons entirely beyond their control. Thank you.
Thank you, Mr. M. Questions, colleagues?
Mr. M?
Yes, Justice Matopo.
Just a practical
I beg your
approach.
pardon?
Just a practical approach. Is it possible that your clients can be successful in these proceedings, the other 2 parties not? And is it also possible that the Labour Party can be successful, your client, and the other party unsuccessful? The Labour Party's case, as you heard, has rolled away from the disputed facts in the Electoral Court. You have sought to address it head on, to say none of it exists, and if there is, it should be construed in favor of your client. So what I want to establish is that, can this court be in a position to say, you are successful, they are not, or they are successful, you are not, or vice versa? All the permutations.
No, I appreciate the question and thank you. It's to a large extent, I can't take my submissions further than those submissions I made in response to His Lordship Justice Majid's question. What you can't do with respect is preclude my client, who's exercised all of their rights, gone to the Electoral Court, lost 3-2, come to this court, and non-suit my client just because there are other people who didn't exercise their rights, or because their cases weren't as good as mine. I would hope, and I certainly don't say that facetiously at all, that each matter will be decided on its individual merits. And if a party hasn't made out a case for, I'm talking within the context of the parties here, not broadly in this 35-65%. If there's a party here that hasn't made out a case for the relief it seeks, it shouldn't get the relief. If my client hasn't made out a case for the relief it seeks, then it shouldn't get the relief. If Mr. Loxton's case, the client has, then he's entitled to the relief.
Well, let me try and understand it. At the heart of all these 3 applications is the fact that the system did not function. If you are to succeed, we have to make that finding. And if they are to succeed, we also must arrive at that finding.
Well, as my learned friend quite eloquently set out, or my learned colleagues in their heads of argument, there really are 2 factual issues. The first is, did the system malfunction? The second is, did the malfunctioning of the system result in the inability to comply with the item 9 deadline? So I submit that it's not merely was the system malfunctioning or not fit for purpose. What was the consequence upon that? It may have been that parties who didn't even try the submission process, I don't know on what basis those parties get to benefit those parties who had similar complaints and exercised their rights from being allowed through that same gate, from a practical perspective. But that's obviously dependent upon the worst case scenario. As to the specific facts, I submit that there must be a fact-specific determination on those two questions. I'm sorry, I can't give a better answer than that.
Thanks.
I tried my best, but thank you very much.
Mr. M, this side.
Yes, Justice McLanga.
Yes. I will, for convenience, refer to the evidence that that is before the Electoral Court, that sought to address the question whether, that is from the IEC's side, whether there were any problems at all with the system. Let me just loosely call it expert evidence in quotation marks. Yeah. I want to know what differences in substance, not detail, there are between that quote-unquote expert evidence and the expert evidence that has been tendered before us.
Well, there are three fundamental differences. The first is that all that was put up before the Electoral Court were reports. That's the first difference. Not confirmed under oath, not explained. And we took issue with that. They're unexplained and they're not confirmed under oath. But as we read them, they're irrelevant because it's not about whether the system was live. That's the first question. The second issue is that the report that is now put up is more comprehensive than that report, firstly. That's before the Electoral Commission. And secondly, it's not just a matter of the affidavit being a confirmatory affidavit. If you consider that affidavit, it's a substantive affidavit in and of itself. And it provides the explanations of the report that weren't provided before the Electoral Commission. And the third thing is, my client is obviously prejudiced in circumstances where in these proceedings it doesn't have a right of reply to deal with evidence which it took an issue with about being inadmissible and irrelevant in the electoral court, and now being presented with it. Really, it's a collateral challenge through the side door because it's in the Labour Party matter. So I submit that those are three vital considerations that need to be kept in mind, whether considering the admissibility or the impact of that evidence within the four corners of my client's case.
Thank you.
Thank you.
Thank you, Mr. Ram.
Thank you very much, and thank you for the hearing.
Mr. Ramait.
Thank you, Deputy Chief Justice Maya. Vilagazi, I'll be standing in for Mr. Ramaid in respect of a reply. Justices, I'm not going to take up much of your time. I get the feeling that this court may be slightly confused in terms of what exactly our case was. The Commission has come here and said that we did not upload a list in time. However, Deputy Chief Justice Maya, you indicated that we had uploaded a list at 16:59.59. And by virtue of that, that is before 5 p.m. of the cutoff time. If I can just refer you as well to the bundle, please, where this issue of us not having a list is actually put to bed. Page 255 at paragraph 11, please, which is the answer of the Commission. And I just wish to read that into the record. Paragraph 111, page 255. It says, I admit that for some regions, it uploaded the requisite supporter information and signatures. But for the only region for which it nominated a candidate, Free State, it did not upload any supporters' signatures. Now, all of a sudden, the game has changed because there is confirmation that a list was uploaded. And I think it was Justice Majid who indicated in the Liberal Party case that Section 28 does not come to our rescue. And he says that in that Liberal Party case, the court had said it is to rectify other failures. However, the starting point of that case was that there was no list at all. So now it is for this court then to tell us, as the applicants, as well as the general public at large, whether a failure to upload signatures is equivalent to a failure to upload a list. Because if it is not, then what you have is you have a list, and what you have is non-compliance with what that case called rectify other failures. So then, in terms of Section 28, can the submission of signatures be rectified, and do they fall into other failures? So it's my submission, Justices, that the Liberal Party case is actually different insofar as the words that were used by this court in explaining what that failure was versus the failure that we have here. The second thing is, if the cutoff time was at 5 p.m. and somebody submitted at 16:59, is that before cutoff? And I think you can only come to one logical conclusion, that it is before cutoff. And by virtue of that, there was then a list, and that list was the Free State. And because then we did not submit the signatures, that could have been rectified, which would have been, I think it was you, Deputy Chief Justice Maya, that asked when was that date of non-compliance. That would have been the 11th of March. Insofar as the relief is concerned, we are advised by the Commission that because there was no compliance, we did not successfully submit a list. But, pardon me, at page 101, which is, in fact, the candidate list in particular. I do apologize, I'm just trying to find it. That candidate list did show that at 1659-59 we had a submission, and then it showed again at 1700 we had another submission. Now, that document that the Commission refers you to is problematic on two fronts. If it says that at 1659-59 our first candidate was captured, and then it says our last candidate was captured at 1700, immediately that implies that two candidates were captured. However, we are told that we only submitted one. Be that as it may, the bottom line is that there was a list that was actually then captured by the system. Insofar as the relief is concerned, the first question that this court needs to go to is ACDP case, where this court considered the issue of strict compliance versus substantial compliance. And I think at ACDP there was no compliance because there was a failure to pay money. However, in this case, with the Commission's own evidence, there is a list that has been supplied. So that, at the very least, ought to mean there was compliance with the requirements of Section 27. If, of course, then that this court finds then that there is compliance of some kind by the applicants, then opening of the portal is not beyond reason. Because had that happened on the 11th of March, then we wouldn't be here today as the applicant sitting in. Had the Commission actually exercised the rights it is granted by Section 28, we wouldn't have come to this court. So, Justices, we submit that the relief that we are seeking is, in fact, achievable. And insofar as costs are concerned, I think I go with the rest of my colleagues, where I say, especially the applicants, that we are all here to protect our rights. And BioWatch, and I think Affordable Medicine has gone as far as to say that. We are not here for a frivolous matter. We are here for a matter that affects many disenfranchised people. I'm ready to take questions, Justices. Thank you.
Mr. Villagas.
Yes, Justice Matupu.
Please help me to understand your case. Absent compliance with the IEC were the signatures only.
Indeed so.
Everything else, the names, particulars, everything that was required was on the portal system.
Indeed so, Chief Justice Matupu. Can I just refer you, please, if you don't mind?
My papers are in a mess.
Pardon me,
Which paragraph?
if I may, page 228 of of the bundle, page 228, and in particular, I'm looking at paragraph 26.
26.
Now, that paragraph is headed in a deceiving manner because it uses the word AASD did not comply. However, if you go to that page, there is a photographic image, so a spreadsheet, and there's a highlight in green on that page, paragraph 26. And it says provincial, and it says region free state, it says African Alliance of Social Democrats, it says unrepresented, and then the question is, candidate/S captured, and it says yes. So the only outstanding thing was, in effect, the signatures, which is what I was saying when I said that is a failure that we submit the Commission had the power to rectify. If there was no list, then Justice Majid's case in terms of Liberal Party then would be applicable. However, in this case, it was simply the signatures.
So you would contend that this brings you within the ACDP case? Remember, in the ACDP case, they paid the deposit, but it was not allocated to the right channels.
Indeed so. So, Justice Matupu, when it comes to the issue of substantial compliance, I think this court itself said we need to follow a common sense approach of looking at the facts as they are, not necessarily what we think they ought to be. In this case, there was a submission of a list. There was the payments of all the other monies which were required. There was uploading of ID numbers, etc. The only outstanding issue is the issue of signatures. So let's use a mathematical precision to it. 3 out of 4 was satisfied. That puts us at 75% substantial compliance.
Well, it makes me think. But there is a big but there. Is it permissible that you, in terms of the rules and the regulations, that you have to comply that way? In other words, if I were to use the flight example, you are in the lobby at the airport, you've checked in and everything else, and then you don't go to the runway to board your flight, and it takes off. Are you going to say you're on that flight?
Justice Matupu, let me give you a better example. You are inside the IEC's offices. You have got your badge in your hand. You've handed one over, and then cut-off time arrives. They've accepted that one that you've handed over, 1659:59. Cut-off time arrives. Where do you stand? My submission, Justice Matupu, is that you've substantially complied. Now, the example that you use about a flight, I could take it one better. Between the airplane and the last boarding gate is known as a chute. So if you are inside the chute and facing the door of the airplane, are you effectively inside the airplane? Can they leave you? No, they can't, because you're already inside the chute.
You know, that causes me problems. and I'm speaking for myself. Perhaps let me leave it, maybe my colleagues will take it.
Mr. Vlegas,
Yes, Justice Mahlangu.
still on the page that you had referred us to, para 28, 29, and 30, I would like to read page 2 to 9 of your papers,
Yes, Justice.
where you showed us the table. Now 2 to 9.
Yes, indeed.
I'll read 28, 29, and 30. Maybe you can comment on that, just to clarify. At 28, you said it stated that while it uploaded sufficient supporters for multiple elections, it did not upload candidates for any of those except for the Free State provincial election.
Indeed.
It therefore cannot compete in those elections.
Indeed.
Is that correct so far?
That's correct.
So the only province, it will be the Free State province, but
Indeed.
it's still going to go to the signature issue.
Indeed, sir.
Okay. Now, 29, it then says, for the Free State election, although ASSD uploaded sufficient supporter information, it did not upload any supporters' signatures. And then it says section 27(2)C, capital B, Roman figure 2, requires parties to submit the names, ID numbers, and signatures of voters. It therefore cannot compete in those elections.
Indeed.
Do you want to comment on that?
Yes, I do. Thank you for that. It's on those reasons, Justice Mhlanta, that I indicated that the Liberal Party case as given to us by Justice Majid was actually not appropriate in this case, because that one was quite specific to candidate list. Now, if you look at Section 28, it says that where a party has submitted a candidate list but has not fully complied. So there are two parts to that. And the question the court must ask is, did you submit a candidate list? Give words their ordinary meaning. Yes. All right. But it also turns out that you were not fully compliant in terms of other avenues. Now, if candidate list is put to the side, this then becomes effectively a other failure, as was described in paragraph 22 of the Liberal Party case. This is what that other failure is. And so, in effect, that could have then been rectified on the 11th of March by the Commission when it dealt with issues around non-compliance with the submission of lists.
So for
yes.
the Free State one, the list had been submitted.
Yes.
And what was outstanding? The
It was
signatures.
signatures.
So the Commission would have to notify ASSD that it has not complied and it must comply.
That's exactly what
And
my
submit the
senior
lists.
wanted to say.
That's what you say.
Indeed. So.
Now, the next paragraph, you then say it admits that it did not comply with the requirements of Section 27 in the prescribed manner, by the prescribed deadline for any election. That is why it seeks the opportunity to enable it to submit the outstanding candidate lists. Why now? Because you missed the deadline for the candidate lists.
Indeed, so. Justice Mhlanga, and this court has got all the powers to it in order to give us an equitable order. If this court finds that paragraph 30, which you've just read, is not in line with this court's thinking, this court must still consider whether it will grant us the relief insofar as the Free State is concerned. Because there, it is undisputed that there is a list, and the only outstanding thing is the signatures. So this court may well deviate from what's written and paragraph 30 is simply us saying, we realize that we were short, but our understanding of the rules and the Act were that Section 28 put a prerogative on the Commission to notify us. So if we don't make it through into the national elections, that's this court's prerogative. But insofar as us having satisfied the Free State's requirements, we are certainly saying that this court should consider allowing us to partake in that election.
Thank you.
Okay, let's just get this clear. You rely on Section 28 and you distinguish Liberal Party, right?
Pardon me, Justice Majid?
You rely on Section 28 and you distinguish Liberal Party in respect of the Free State.
Indeed, sir.
Let's look at the Act. The Act says this, Section 28. Do you have it there?
I will open it now, Justice. Yes, Justice may proceed.
Let me go back to 27. 27CB, small c, capital B, deals with signatures, names, identity numbers of supporters. You accept that?
I do.
Do you accept that?
I do.
So 27CB, remember that. 28 reads thus. If a registered party that has submitted a list of candidates has not fully complied with, and I'm going to go slow, Section 27(2) (27CB), small c, capital B, deals with signatures, names, that are new were introduced with effect from 19 June 2023 as a result of Section 3 of Act 1 of 2023. That's the Electoral Amendment Act. And then it pertinently says, as far as 28(1), where CB is excluded, it says the same thing, with effect from 19 June 2023, and it is by virtue of Section 4 of that same Electoral Amendment Act. So that is why you must read the Act now with a general principle of Liberal Party in mind, but bearing in mind that CB is expressly excluded from matters that can be rectified. You see the problem that I have?
I kind of see it, Justice Majid. If I can just refer you to one last part in order for me to complete my submissions on this specific aspect. If you go to page 31 of our bundle, paragraph 20, page 31, paragraph 20. It reads as follows. Providentially, the AASD has, however, fulfilled its requirement to obtain 13,931 valid signatures. And then it goes on to speak about where they are sitting. So it says signatures as well. And then it tells you where they are sitting. So it's sitting on the OCSN portal, as it were. I'm sorry, my laptop just switched off. So in effect, if the argument is accepted by the court that, pardon me, thank you. I do apologize. Yes, thank you. I'm just trying to find it. If the court accepts that we had gone as far as we could effectively before 5 o'clock, and we had followed the majority of these steps, then I would submit that that, in effect, is where substantial compliance really comes into it.
See, Mr. Velakazi, let me just say generally, in respect of all these cases, I think the aim with the Constitution, with the right to vote and the right to stand for office, is aimed at inclusion. I think the Constitution is aimed at, because we were denied, those of us who were of darker hue, were denied the right to vote. It's very, very particular, and somebody called it red rights, first generation rights. Constitution is very adamant about that. But having said that, there must be rules. The rules must be certain, and the rules must be adhered to by everybody. You can't make a fish of the one and fowl of the other. And so, when I put all of this to you, I'm saying to you that Much as we would like to help you, and I assure you the court would want to help you where we can, we are bound under the principle of legality by that which we can do, and that is the law. And if the section specifically excludes what you want us to do, then we can't do it. Because it's not a question of or, it's a question of 27CB is very clear. You must submit in the prescribed manner the names, identity numbers, and signatures. Now, these are just allegations for now, but there are allegations already of forged signatures. Do you understand why these are important and why, if they are excluded for rectification, we must apply the law as it stands? We can't make up the law, we must apply the law.
I understand you, Justice Majid. Justice Majid, I can't take my submissions any further on that.
Yes, thank you. I think you've done very well, actually. Thank you.
Indebted.
I've written no, by Jerry. I omitted to answer a question of yours about costs.
At section 27.2, so 27.1 requires the registered party who wishes to contest an election to submit a list or lists. And 27.2 says the list or lists must be accompanied by various things. CB we know is the names and signatures, and that also asks the court to look at E, which is the deposit. And those are the two that are not in 28.1, the signatures, supporters information, and the deposit. So those are the two that cannot be remedied if they're not met by the deadline. What can be remedied is A, which is undertakings, declarations, and so on, signed by the candidates. So it very specifically determines what can be rectified after the date and what cannot. And it's important to be clear about what the consequence of Mr. Vilakazi's argument would be. It would be that every single unrepresented party did not have to submit signatures by the deadline. It could have submitted no signatures, and the Electoral Commission was obliged for all those parties to afford them an additional opportunity under Section 28 to comply. If parties had known that, I think they might have managed their uploading very differently. But they didn't read it that way because that's just not what the section says. It doesn't permit rectification of signatures or non-payment of deposits for good reason. And so that's why, unfortunately, the ASD, even though it had a candidate for the Free State provincial election, didn't have any signatures. And so it can't be a question of substantial compliance. It's not, well, I complied with 3 out of 4 requirements. If there are 4 requirements and you didn't meet 4, you haven't complied. It's not about substance or not. You just haven't complied.
Yes.
Thank you. That's my only submission, Deputy Chief Justice.
All right, thank you, Mr. Bishop. Judgment is reserved, and perhaps just to, sorry. Mr. Roxton, you see this ad hoc manner of doing things. You made a submission about costs. Mm-hmm. Do you have anything to say to that, Mr. Bishop?
No, I heard Mr. Bishop, and I heard him mention that there are conflicting decisions about whether or not to award costs against the Commission. And in this case, my instructions are to award those costs because, in effect, we've put up a case against the Commission, and we find out at a very late stage that there is material information which we didn't have before. So we're persisting with that cost order. We understand that this court is at liberty, given the Commission's duties And I understand the argument that when a regulatory body performs its duties, if it doesn't act mala fide, the court will often not award costs. I take that into account, but my instructions remain the same.
Okay.
Thank you.
That is everything. Okay. Judgment is reserved. And as I was saying, perhaps just to reassure the parties, we are acutely aware of the agency surrounding the matters and the looming deadline of 17 May. So, corrections.
Yeah, madam. Sure.